Good evening, everyone. We will go ahead and get started at 5:34. This is a continuation of our public hearing from last night. I will ask the audience to please mute their cell phones and any devices. Thank you. Where we left off yesterday was with opponent testimony, so we will pick up there. And our goal is to get through as many people as possible tonight. We really want to hear from you. We will begin the verbal testimony portion of our proceedings. And I will take a moment to explain again how verbal testimony will proceed so that everyone is prepared when it's their turn to speak. Names will be called in groups of 3 tonight. Each person will be identified by their name. The first person called will proceed directly to the testimony table. The remaining individuals should take their corresponding seats in the front row. We have some chairs marked for you in the order that your names are called. Your name will be called twice. If you do not visibly move toward the testimony table, or for those joining via Zoom, if you do not interact with the webinar staff by the second call, your opportunity to speak, including any time that has been ceded to you, will be forfeited. Please be mindful of your allotted time. If you have received additional time through seating, you should already know the total amount of time you've been granted. When you take the stand, begin by clearly stating your name and address for the record. Wait for the timer to be set before beginning your remarks. And if you do have seated time, it'll take our staff just an extra minute to get your correct time up and going. At the end of your time, you will hear a bell. If you continue speaking beyond that point, you will be informed that your time is up, and your microphone will be turned off so that we may proceed in an orderly fashion. Please also be aware that the county's rules of decorum are posted throughout the venue. If these rules are not followed, speakers may be stopped or asked to leave the room. Lastly, as chair of the Board of Commissioners, I reserve the right to cut off testimony that is repetitive, harassing, defamatory, or otherwise abusive. If you are abusive or less than polite and you are asked to leave, we do have a couple deputies that can help escort you out, but I don't think we will need to do that tonight. So with that, let's get started. First up, we have Jeffrey Kleinman, and I believe he is joining us online.
Correct. Can you hear me, Madam Chairman?
Yes.
Okay, thank you. Appreciate the opportunity to testify. I'm the attorney for Valley Neighbors. My address is 1207 Southwest 6th Avenue in Portland. I am not seeing the clock yet. There we go. Again, I represent Valley Neighbors. I have done so since 2021. The last application, which was rejected by the Planning Commission, then appealed to this Board of Commissioners, and then the applicant withdrew the appeal before it could be decided. I made a preliminary procedural objection. I'm just going to spit out very quickly in the memo that I believe has been hand filed tonight. There was a little trouble getting that transmitted and printed. So I have emailed a copy as a precaution. There was a change in policy in the announced policy of the county on accepting email testimony while the record was still open, but the hearings had commenced. So nothing was to be accepted electronically after yesterday's commencement of hearing, and that denies people their substantial rights. I didn't know what happened to me, but I do believe a written copy has been filed. The emailed one might be clearer. This is very difficult for me. I've been doing this for a long time and have not found it necessary in the past. But please bear in mind that this is our last shot. And when you commence your deliberations, we won't get to speak up. And what experience indicates with respect to Republic and this matter is that there is some steering, um, some herding, some Australian sheepdog type activity going on. It's a little bit mysterious, but you know, things have been said about the law that are just not true. And I expect they may be presented to you again, whether by county council or planning staff, when the record is closed and we don't get to talk. So very quickly, I'm going to list those things. Yes, by law, the existing operations of Republic and its impacts are relevant to your consideration. Violations of past permits and conditions of approval are relevant. Eyewitness testimony can be weighed and found to surpass that of experts, and I'll talk about that more. The Webster's definition of adjacent is quite broad and not as narrow as stated. Franchise agreements can be relevant. The law doesn't prevent that, and I'll explain why they may be relevant here. Um, a bit of perspective may be helpful to your consideration. I explained what happened to the 2021 application, which called for the filling of Coffin Butte Road. There's a little concern that if this is approved, that could be done without much public process, just by a street vacation by the county. So I don't think I'm giving anybody on the other side any new ideas, unfortunately. Um, so after the last application failed, the county put together a very expensive Benton County Talks trash process, in which very well-meaning and dedicated citizens devoted thousands of hours of their time, although to what end, nobody still knows. The board accepted but did not adopt the lengthy BCTT report. Then, with the current application pending, the county or impending, the county disbanded the Solid Waste Advisory Committee, which is by code supposed to advise on this, substituted the Environmental and Natural Resources Advisory Committee in its place, and then staff, this goes along with the herding that I mentioned, told NRAC they couldn't accept public testimony at their hearing. Nonetheless, on April 16 of this year, NRAC delivered a long and blistering rebuke recommending denial by the Planning Commission, and the Planning Commission held 15 hours of hearings and then denied the application and adopted findings. So facing time constraints and unwilling to rely on staff to fully, accurately, or meaningfully incorporate their findings into a decision, Planning Commission members in their discussion on the record made findings explaining the decision they were about to make. And those have been incorporated into the appeal decision. They're part of the decision. They are intelligent, they are complete, they are not internally inconsistent. Um, they did as well as non-lawyers, non-planners could do in drafting findings, but they were unwilling to rely upon folks who are beholden to the applicant to write their findings. And with that in mind, I would ask, please, that if my clients are successful in defending the Planning Commission's decision, that you state when you make your decision that staff is to confer and cooperate with us or with me in the drafting of their findings. So after they filed this appeal, the applicant asked for and received several weeks of additional time before proceeding to staff report and notice of hearing. What did they do with that time? They hired two consulting firms, two PR firms, to come up with a campaign to pull together testimony in support of the application, rather than substantively addressing the concerns that community members have raised. As the current application has moved through the process, the applicant and staff planners have added more and more words to the conditions of approval and to the explanations of the application without ever achieving or showing the achievement of compliance with your code or setting out conditions of approval which successfully mitigate the impacts of this expansion. Now, with respect to the attempt to denigrate the testimony of lay people who have a lived experience, I'm going to read you a little bit from the Luba's decision in Stop the Dump Coalition versus Yamhill County in 2015. This is not a quote. I'm going to summarize the decision in part. The testimony of affected citizens based on lived experience may be believed and can prevail over the testimony of paid experts. And another rule from that case is that evidence regarding impacts of an applicant's nearby existing operations is relevant in evaluating the proposed expansion of that operation. And ironically enough, the application in Stop the Dump was for a southward expansion of a then long operating and existing landfill. I mean, it couldn't be more squarely on point. But the applicant and its consultants demand that the community and this board accept their paid-for hypotheses over reality. In a nutshell, the applicant is asking you, who are you going to believe, us or their lion eyes, ears, and noses? And they present that as a rhetorical question, which it is, but the answer is the opposite of what they think it is. So we've stated the point colloquially, but the fact is that the applicant's effort to dismiss eyewitness testimony is, quote, anecdotal and, quote, speculative, and therefore irrelevant or entitled to much less weight, has no legal basis at all. The testimony of the affected community members who have suffered from the impacts of the dump is factual, it's true and correct unless proven otherwise, and it has not been proven otherwise in any instant. It is the distant paid consultants, many of whom may never have visited the site or even been to Benton County except for a hearing, whose testimony is speculative. On a related note, the applicant's apparent willingness to pay the county for a code enforcement person who could not conceivably be objective when they're paid by the applicant does not get them anywhere in terms of satisfying conditions. And not only that, if you rely on conditions, the adjudication can move on to the courts and can take years, lasting beyond the expiration of the permit, and doesn't do any good. So these things need to be addressed now and successfully. Stop the Dump and other cases also call out very clearly that the applicant always has the burden of proof. Consistently in this case, the applicant has tried to shift the burden of proof onto the opponents. The law is that that the applicant always has the burden of proving compliance with all the applicable criteria, or if the county or city is to rely on conditions, that it must be clear that those conditions are feasible of compliance and will cause the standard to be satisfied. That is not the case with the conditions here. If I have time, I'll talk about that a little bit, but many witnesses are prepared to discuss those issues. Um, there's also a suggestion that based on something in the BCTT report, that the Planning Commission went far beyond the scope of what it's done before in terms of assessing impacts and distance from the site. That's because they don't have applications with this type of scope and impact as a normal matter. The Both the staff and the applicant have pointed to Webster's Third New International Dictionary for the definition of adjacent. And I would say that definition is actually helpful here if you actually read it. It's in our memo, it's in one of the staff reports, because it defines adjacent as, quote, not distant or far off, nearby but not touching, uh, relatively near and having nothing of the same kind intervening, or having a common border. So there's numerous definitions, and we don't make any argument to go beyond the definitions that are available to you. The definitions afford you great discretion. But even if we were to only take into account the mapped so-called adjacent properties indicated in the materials filed by the applicant, the testimony of folks who farm and engage in forestry, according to that map, adjacent to the site, are sufficient to defeat this application, and it only takes one. The criterion relating to the character of the area is not confined to adjacent properties. The character of the area is clear from the record and will be made more clear by witnesses, but there seems to be an implicit argument from the applicant that, in essence, we have already ruined the area. And that's the character of the area. So it doesn't matter what we do to the south. And of course, that's not true. The movement to the south changes everything and affects a different area as well as the original area. Reference has been made to trying to define seriously and significant. We addressed those terms at length at pages 5 through 7 of our May 5 memorandum to the Planning Commission, which is part of your record. And I think you just need to place yourself in the shoes of a property owner in any of the affected area to realize that the impacts are serious and significant. You wouldn't live there on a bet. You wouldn't farm there on a bet. And based on testimony of farmers and foresters, there will be violation of not just the basic conditional use criteria that we've addressed, but also those that apply in the forest conservation zone, where a large part of this project is going to take place. The applicant's activities are not permitted to force a significant change in or significantly increase the cost of accepted farming or forest practices or increase the fire hazard. And, I direct your attention to the earlier submittal by the Adair Fire Chief, indicating inability to serve. And of course, this expansion creates a larger area that they would have an inability to serve. So the evidence in the record before you establishes unresolved pre-existing violations of criteria. Now they would be moving south. You would think that if the applicant could be relied upon to somehow comply with these conditions, which don't even really achieve the mitigation that they supposedly achieve, that during the 4 years since 2021, when they've been up against this and BCTT has been working, et cetera, they would be on their very best behavior and doing everything that they can to show that they mitigate. And this stuff that people talk about, the stink, the noise, the litter, the litter in farm fields jeopardizing livestock doesn't happen, but they haven't. It goes on, and that's what you could expect. Again, you would expect them to be on their best behavior, and this is the end product. Same old stuff. One of the supposed principles of law that the applicant has presented to you is that you can't take the franchise agreement into account. The one case I found in the Oregon Supreme Court that might somehow relate to that doesn't stand for that principle at all. It relates to the Grabhorn landfill in Washington County. But what's relevant about the franchise agreement is that if this application is approved, then the tonnage cap on all the applicant's operations goes away. So they have apparently proposed some sort of condition imposing a new tonnage cap that would affect their other operations, such as the one in the old quarry that they're filling now. But those properties are not part of this application and would not be controlled by any such condition of approval. They've got permits for their sites to the north. They're filling the old Knife River Quarry under those permits, and nothing you do here will change that. And they have, responding to some of the testimony you heard in favor yesterday, they've got years of capacity at that site, leaving plenty of time to find something suitable to replace Coffin Butte as a regional landfill. On the conditions of approval, my memo presents the law to you. And as I said, other folks are going to be discussing them more specifically. But my point, which I made to you earlier, is that in essence, as these conditions have evolved, let's try this. Let's try this. Let's try that. It's just a whitewash. The conditions do not have the effect that they purportedly have. Again, there has to be substantial evidence that the solutions to the identified problems that are presented in the conditions are possible, likely, and reasonably certain to succeed. And that's for a number of cases, including Meyer versus Portland and Gould versus Deschutes County. The same point has been made many times by Luba and the courts. Conditions cannot defer the demonstration of compliance with the applicable approval standards to a future point in time where there are no opportunities for public participation. And the opportunity of this board, for example, to deny the application or cut it off. So I've got a little under 2 minutes and want to talk about at least a couple of conditions, and I'll tell Carly, I'm going to shut up at 0. So conditions P2-2 and OP-3 relate to noise, and the second one covers the long-term operation of the fill. There's nothing in there that will actually control noise of anything other than hopefully the equipment of Republic operating on top of the landfill, but not Republic's trucks, which, by the way, are only 1% of the traffic going to that fill, or the trucks that are owned by any one of the other companies and jurisdictions delivering to the site. And even Republic's own trucks that are out there in their franchise areas picking up trash require regular, normal backup beepers, not proximity beepers. That's required by law for their operation on the public streets and roads. So all the trucks going up there and their Jake brakes and their motors and their clanging tailgates and their beep, beep, beep are uncontrolled by the conditions of approval, and they can't be controlled. In my memo, I also discuss odor and litter, and I'll be quiet and happy to answer any
Thank you,
questions
Mr.
any of you
Kleiman.
may
Your
have.
time is up. Thank you. And thank you for your patience as we bumped you from last night too. And I think this is a good time for me to remind people what's most helpful when you are speaking to us is to speak to how the criteria is met or not met. That's really going to help us in making our decisions. And also, I'll just note that you don't have to take all the time that you are allotted. You are most certainly welcome to. If you finish a little faster, that will leave some time as we do have a long list of people. So next up, we have Dr. Joel Geyer, Mark Yeager, and Kate Harris.
Yeah, good evening, Chair Wise, Commissioner Shepherd, and Commissioner Malone. Thank you for holding this hearing for a second evening here. It's going to be a long night for everyone I know. My name is Joel Geyer, resident at 38566 Highway 99W, Corvallis. Before I start on my own testimony, I'd like to read the following statement by Dr. John Selker, by his permission. Dr. Selker is the University Distinguished Professor and Associate Director of the Water Resources Engineering Graduate Program at OSU. He's outgoing President of the Hydrology Section of the American Geophysical Union and an AGU Fellow. Here's his statement. The landfill at Coffin Butte has long employed a dangerous and harmful means of disposing of its liquid leachate waste by contracting with a service, the Corvallis Wastewater Treatment Plant, that cannot prevent many of the most toxic components from entering the Willamette River. The treatment plant is designed to digest human-generated waste, not the heavy metals, chlorinated compounds, PFAS, etc., found in the Coffin Butte leachate. This implicates the city as well, in that their participation directly leads to contamination of the Willamette River. But for the purposes of this hearing, the point is that the operators of Coffin Butte have not sought nor implemented environmentally responsible measures to avoid contamination of our environment. To extend a permit for further contamination would be complicit in this tragedy. Now turning to my own personal testimony. I have degrees in mining engineering and geology. I work internationally as a recognized expert in field of fractured rock, how water moves through it, and how contaminants move through it, with 38 years of professional experience. I have peer-reviewed publications both in that field and my favorite side gig, which is bird conservation research. First, about birds. The staff report fails to show the current active location of the great blue heron rookery. I provided extensive documentation for the Planning Commission. The herons are nesting just across the road in Oregon ash trees, which was confirmed on record by ODFW's biologist. Those ash trees could die within years due to the invasive emerald ash borer. You've probably heard about it. I placed an article about this threat in your record. I think you'll find it interesting beyond this hearing. But before I got those degrees, long before, I lived on a dairy farm where one of my daily chores was to feed our calves. I know what it's like to watch a calf die. In the Planning Commission hearing, our young neighbor, McKenna Bradley, spoke bravely about the risks to her cattle from airborne plastic. She can't be here tonight, but please listen to her testimony on video. She spoke of the risk of even one plastic bag. Another neighbor, Angela Kruger, sent in a video where she snatched a bag from her cow just in time. Those videos are on the record. Speaking of dead cows, on our farm, when one died, we would call a rendering truck. Dead cows shouldn't be going to the landfill, and landfills shouldn't be putting cows at risk to die. That's just wrong. The applicant has shown no ability to prevent that by keeping trash on their site. It will only get worse if they build a new landfill closer to the Bradley's pastures. The proposed conditions of approval on this issues don't work now, and they won't work on the expansion. All it takes is a day with warm thermals that lifts plastic bags up above the treetops, and I've seen it happen with my own eyes. The company's proposed remedy to send strangers into these pastures to look for trash is itself an imposition on our neighbors' right to privacy. And if these crews are anything like the roadside trash crews, they're going to miss a lot. But mainly, I'm here to talk about groundwater. In my written testimony, I've addressed technical aspects regarding impacts on water levels in wells and natural springs on Tampico Ridge. This is a real risk not addressed adequately either by the applicant or by staff's proposed conditions. There's also the arsenic question. Wells just east of the existing landfill, the direction that groundwater flows up from under that side of the landfill, show arsenic levels that are highly unusual for this part of the valley. This has been going on for 30 years. Republic's consultants have tied themselves up in knots trying to explain away this issue. First, they admitted it was seepage from the landfill, but then they fixed it. Some years later, they told SWAC that arsenic doesn't usually come from landfills. Then they blamed it on sediments from an ancient bog and so on for 30 years. Now they have a new idea that low oxygen under the landfill causes arsenic to leach out of the basalt. They sent some rock samples to a lab. Never mind that about half of their samples were so low in arsenic that the laboratory couldn't detect any, and the rest were barely above that level. Not to mention, you'd need to suspend all evidence of timescales for rock alteration processes for their latest idea to work. Why don't they just work with DEQ to add monitoring wells on state land out to the east and figure out what's really happening and make them deep enough to answer DSAC expert Dave Livesey's concern that their current wells are not deep enough. You have his report on the record too. Landfill leachate is dense compared to fresh water, so a plume from the leak will want to move downward. There are households and agricultural wells east of the landfill, plus a very popular fishing pond. Why are they offering to test wells uphill to the south, but not out in the flats? That's a red herring. Look over here, not over there. Turning back to these adjacent properties on Tampico Ridge, the applicant tells you to ignore all of the construction impacts, such as blasting and noise. Never mind that the construction period will extend over 3 years, half of the claimed 6-year operating life. And impacts on wells and springs will be permanent, effectively. This is because the proposed new landfill is badly located and will need to be kept drained at its base. Unlike better sited landfills in flat terrain, this one is on a hillside where groundwater can be right up to the surface during the wet season. If you don't keep the base of the landfill drained, water will build up in the hillside and the landfill ends up basically as a dam, not an earth-filled dam, but a trash-filled dam. That would cause a whole new set of problems for them. So they need to keep it drained, not just during construction, but also during operation. And even after that, decades into the future. So yes, this is a long-term impact, and the applicant has not done any serious investigations of groundwater conditions in basalt bedrock under Tampico Ridge. Their model that they hinted at in earlier statements turns out to contradict their own prior interpretations of where groundwater flows. It is neither fit nor purpose, nor conservative as claimed. Again, please see my written testimony for details. Members of the Planning Commission were quick to recognize the problem, especially Commissioner Lee, who put her finger squarely on this issue. Now, late in the process, staff has asked the groundwater consultant to try to plug this gaping hole in the application by drafting a brand new set of conditions. These conditions call for Republic to start to investigate groundwater conditions below Tampico Ridge, south of the landfill's footprint, but with no guidance on how far south to go. Gathering data is a good idea, always a good idea. There's really no reason why the applicant couldn't have started on this years ago to gain a better understanding of this new landfill site. But their pattern seems to be just to do the bare minimum. Past behavior is the best predictor of future behavior. You can expect that if you approve this plan, the applicant will again just do the bare minimum, if even that much. If they do follow this prescription, will it work? No, because there's no supporting basis for staff's recommendations. There is no analysis why 4 boreholes is the right number. Why not 5 or 6 or 10? Nor is there any guidance on where these boreholes should be placed. Normally in fractured rock, you'd expect to start with structural mapping, followed by some geophysical methods. before you even start to drill the first borehole. Each borehole should be placed to answer specific questions in a real site investigation. But these conditions, in effect, just say drill 4 boreholes and report on what you find and try not to run into too much groundwater. Staff now also suggests that the applicant should run tests to check for groundwater connections with neighboring wells. How would they do that? In my work, this is usually called an interference test. Note the root word interfere. What other permit can you recall where the applicant was told to interfere with neighbors' wells in order to demonstrate there would be no significant impacts on those same wells? There's no remediation plan in the event that this project does lower well levels by 10, 20, 40, or perhaps even 100 feet. No remediation plan for when the Kippers family's springs go dry, or if in summer, water atop the ridge drops too far below the root zones of their trees. What are residents supposed to do? Hire a driller to deepen their wells? Just about everyone who lives in the Coast Range knows that when you go deeper, the water gets saltier. Salty water, like landfill leachate, is denser than fresh water. It tends to stay down there. And a salty well is a useless well. Both the application and the proposed conditions of approval are insufficient to prevent significant impacts on existing adjacent uses and also sensitive wildlife. Please uphold the unanimous decision of your planning commission. Thank you for your time, and I'm happy to answer any questions.
Thank you. Next up, we have Mark Yeager.
Chair Wise, members of the commission, good evening. My name is Mark Yeager, and I've lived in Benton County since 1982. I'm a registered civil and environmental engineer and a certified water rights examiner in Oregon. I also worked in municipal government for more than 30 years in Oregon, involved in many land use decisions. I have served multiple terms on Benton County Solid Waste Advisory Council and Disposal Site Advisory Committee from the 1990s through 2023. I am also a member of the Adair Rural Fire District Budget Committee. I live at 37269 Helm Drive in Corvallis. I appreciate the opportunity to speak with you tonight about the Coffin Butte Landfill expansion. And I appreciate your service to our community. I know this is a difficult process for you and for the community. I've also submitted multiple written comments for your consideration regarding leachate, traffic impacts, and undue burdens. I'm going to speak to you tonight about Coffin Butte history, the land use expansion proceedings since 2020, and some thoughts about unresolvable impacts as a means of denial for this application. Regarding the history, remember that Coffin Butte began as a hole in the ground to burn trash during World War II to support the Adair military installation. It is an accidental dump. When Coffin Butte was first being considered as a 3-county dump in 1973, the chair of the North Benton Citizens Advisory Committee, Arthur Tollefson, wrote to the Planning Commission chair on November 5th, 1973, and I quote, "Let it be clearly understood that we are unalterably opposed to a long-term continuation of the use of Coffin Butte site for its current service area, and we are even more vigorously opposed to the expansion to serve a 3-county area." Well, as you know, Coffin Butte now serves more than 23 counties in 2 states. He also writes, and I quote, "There is a substantial body of facts relating to the unsuitability of this site and the surrounding area, which have seemed so evident to us as to make any consideration of Coffin Butte site utterly ridiculous, totally intolerable. It is the consensus of North Benton Area Committee that the location of a regional disposal facility would be extremely short-sighted and dangerous." Again, quoting, "Coffin Butte is far better suited to be a public park than a public dump." Tollefson was a PhD professor at Oregon State University. The North Benton Citizens Advisory Committee was correct. Here we are 52 years later, the same story with dramatically worse conditions. In 1983, when the Coffin Butte landfill area was rezoned from forest to landfill, The staff report states that the North Benton Citizens Advisory Committee, the Solid Waste Advisory Council, and the staff all agreed with the zone change. They all agreed with the zone change, provided that no landfill be allowed on the south side of Coffin Butte Road. The Goal 5 exception process required for this 1983 zoning of the property from forest to landfill site stated that, and I quote, use of the land south of Coffin Butte Road as a tree farm would not change. The narrative being spun today by the applicant in their PR campaign about quote unquote completing the plan and moving on to this parcel is totally false. The southern parcel was never intended for use as a dump. In 1994, Valley Landfills applied for a conditional use permit to dump trash on the south side of Coffin Butte Road and also requested a zone change to convert 26.5 acres of rural residential property into landfill property. This proposed 1994 dump expansion would have mounted trash on both sides of Coffin Butte Road, intruding ever closer into rural neighborhoods, just like they want to do now. Perhaps more problematic, the 1994 proposed expansion included a specific reference to the inevitable closure of Coffin Butte Road, and I quote, filling on the landfill site zoned land to the south of Coffin Butte Road would eventually require vacating Coffin Butte Road as a through road and using it only for access to the landfill. No doubt, Republic's current proposal is the first step in this plan. Coffin Butte Road is an emergency evacuation route for hundreds of residents of North Benton County. However, after the public outrage over this proposal swelled, the 1994 plan to expand the dump south of Coffin Butte Road and rezone the rural residential property was unanimously denied by the county commissioners. Bob Kipper spoke of those commissioners yesterday. In 2021, Republic Services again proposed to expand the dump south of Coffin Butte Road and close the emergency evacuation route. Public outrage surfaced again. Planning Commission adopted findings based on the evidence, and the request was unanimously denied. Republic Services came back in 2024 and yet another request to expand south of Coffin Butte Road, marketing this as a modest proposal when in fact it is the camel's nose under the tent. After careful consideration of all the evidence, this request was also unanimously denied by the County Planning Commission in August 2025. After unanimous denials by two different planning commissions, Republic Services has now appealed to the Board of Commissioners to reconsider their expansion request. Commissioners, this is your legacy decision. If the 2025 Planning Commission decision is overturned, unlimited amounts of garbage can be trucked into Coffin Butte Landfill as outlined in the 2020 franchise agreement. Contrary to the unanswered question last night, this was a question that Commissioner Malone asked. The proposed condition limiting trash to 1.3 million tons per year does not apply to the land north of Coffin Butte Road. So Republic will be free to bring in as much garbage as they want to the north side of the road since the expansion parcel is approved as detailed in the franchise agreement. That's what's allowed. Also, if this appeal is granted, Republic Services will be free to continue dump expansions without any further county approval or conditional use permits because none are required in the development code. Because Republic owns all the contiguous land, Coffin Butte Road could be vacated by the county. The engineer could say, well, it's a public interest. The road closed and filled with trash without any public hearing process. Well, let's talk about the process a little bit. During the development of the 2020 franchise agreement, it was made clear in the December 2020 staff report from County Council to the commissioners that the county's long-term objective was to get more money through approval of landfill expansion. County Council stated, and I quote, repeatedly, Republic has informed us that its ability to pay higher fees was dependent upon one of two factors, either reducing costs or increasing capacity. We all agreed that it's far, far more likely that increasing capacity would be the route most viable for Republic. And again, I quote, "Once that footprint expands, Republic is confident that it will be able to absorb a higher franchise fee because it will have greater capacity within which to accept waste." So a money incentive for the county to approve the expansion was built into the franchise agreement in Section 4. The county will get at least $1 million more per year if the landfill expansion is approved. Also, as an incentive to Republic Services, the county agreed to remove all limits on garbage intake from any sources once the expansion is approved. That limit is currently 1.1 million tons of garbage a year. This also brings more money to the county. Remember, though, even without expansion, the county is guaranteed a minimum of $2.5 million per year through 2040. Now, I know that you've been advised by your legal counsel that you cannot use the franchise agreement in your findings to justify approval or denial of the application. But frankly, it is the elephant in the room. With this financial incentive on the table, how can the county fairly evaluate the impacts and long-term liabilities associated with approving this expansion? In my prior land use experience, I have never before seen a direct financial reward for approval of a land use permit. The county's failure to push an expansion through the 2021 Planning Commission process resulted in the formation of the Benton County Tox Trash Work Group. An independent situation assessment was requested by the county and conducted by Oregon Consensus to find out why the expansion request failed so miserably. Oregon Consensus found that there was a profound lack of trust between the county legal and planning staff and the public. The report recommended independent planners and legal counsel be hired for any future expansion application to improve transparency and trust. The county hired those consultants funded by Republic Services, but the exact opposite has occurred. The county has instead used those private businesses as a shield and denied multiple public records requests to prevent any disclosure of communications between those consultants and Republic Services. That move has not improved trust or transparency. And like 2021, those county hired consultants have worked tirelessly to advise Republic how to package their proposal to ensure approval of the expansion, and have summarily dismissed as quote unquote anecdotal the many community concerns and impacts of this proposed expansion. The landfill expansion south of Coffin Butte Road is not needed now and not needed for Benton County. The dump will not close if the expansion is denied. No jobs will be lost. Money keeps flowing to the county. Republic Services is obligated to keep the landfill open for Benton County until 2040. They can, and I can tell you that it does not take they cannot, and I can tell you that it does not take a highly paid consultant to see livestock eating wind-blown trash from the dump. How many dead, diseased, traumatized livestock or people does it take to know that this expansion will seriously interfere with adjacent land uses? Blowing trash has not been and cannot be prevented or mitigated by any conditions of approval. The proposed fencing scheme is the same one they use today, and it does not work. The proposal to pick up trash after it arrives on the property is also a little too late. Enclosing the dump in a big bag is the only way to capture the windswept plastic and paper from leaving the site. Therefore, the litter problem cannot be mitigated with any conditions of approval. The same is true for odor. The proposed conditions of approval to monitor odor and investigate complaints do not and cannot prevent or mitigate the odor problems. Investigating after the odor exists is too late, and the odor problems happen all the time. I can attest to that. The offsite noise from the existing dump is incredibly disturbing. Loud engine noises, Jake brakes, banging metal doors, guns and fireworks for vector control. They continue taking, I'm sorry. I missed a page here. Well, anyhow. So the expansion is about Benton County government losing its last shred of control over the future of Benton County. There is ample evidence in the record to support a denial of this application. The hired legal counsel would like you to believe that you cannot consider evidence presented by members of the community, many of whom are highly educated and experts in pertinent fields, or that their testimony has less value than the testimony of Republic's hired consultants, the so-called experts. So there is substantial evidence in the record regarding wind-blown trash and its serious interference on people's adjacent properties. How many adjacent homes and businesses does it take to constitute serious interference? There is evidence in the record by the bit-by-bit horse therapy program. You heard about McKenna Bradley's 4-H program, the Kruger West Cattle Company, owned by Angela Kruger, Ian Finn's home, Prior Thacker's Flower Farm, Rose and Kathy Holdorf's homestead, Sarah and Ken Edwardson's property. The proposal to modify the backup alarms for Republic's on-site vehicles, and I'll repeat that, for their on-site vehicles, Republic's on-site vehicles, cannot mitigate the noise from the 130,000 vehicles per year that come from off-site to the dump. The noise cannot be mitigated through conditions. So speaking to conditions, litter, odors, and noise are all easy areas where the evidence in the record and common sense can be used by you to develop findings to deny this application. This decision does boil down to whether you believe the personnel and consultants hired to develop reports and comments to support the application, or do you believe the community and public testimony and the lived experiences of the residents in Benton County? Your Environment and Natural Resources Advisory Committee also reviewed the application, recommended denial. Your Planning Commission record is clear, extensive, and decisive, unanimous denial. There are no second chances here, no do-overs. If this expansion is approved, Republic Services will be free to expand and exploit as much land as they own, 700 acres, to create a larger and larger dump. In email communications with Republic, the county has invited future zone change requests to allow for continued expansion. In fact, I believe this proposal before you is simply implementation of the plan they submitted in 2021 to close Coffin Butte Road and fill the area between Coffin Butte and Tampico Ridge with trash, same as 1994. The proposed traffic plan and private intense use of Coffin Butte Road for landfill activities will effectively close the road to the public. Do you really believe that Republic is spending all this time and money to get approval for use of this property south of Coffin Butte Road for a mere 6 years of life of the landfill? Of course not. The county has cultivated a monopoly for Republic services, and without meaningful competition, you are listening to one voice. Alternatives are being implemented in many places. We can lead, like Oregonians have done on many fronts. I urge you to stop this and all future expansion efforts. Take the time available to develop long-term plans and take into consideration the concerns of your residents and other dependent communities. We have 12 to 14 years. The landfill will not close if the expansion is denied. No jobs will be lost. It is time for a paradigm shift in waste management in Oregon, and you have a chance for a cleaner, more sustainable future beginning now. Expansion approval means business as usual, with more residents exposed to air and water hazards, serious irreparable harms, and undue burdens, and a Corvallis and Benton County with a reputation as trash town. Quoting from Martin Luther King, the time is always right to do the right thing. Finally, in recognition of the Kalapuya tribe, I want to close by quoting the land acknowledgement statements in the foreword of your Benton County Talks Trash report and other published documents. And I quote, "It is important that we recognize and honor the ongoing stewardship and spiritual relationship between the land and the people indigenous to this place we now call Benton County. We thank them for their continuing to share their knowledge and perspectives on how we care for, impact, and protect the land we live on. I urge you to live up to that acknowledgement and deny this application. Thank you for your time. Happy to answer any questions.
Thank you, Mr. Yeager. Next up, I have Kate Harris.
Good evening, Chair Wise, Commissioner Shepherd, and Malone. My name is Kate Harris. I live at 37268 Moss Rock Drive, Corvallis. I will first read a letter by the Right Reverend Catherine Jeffert Shorey, who still has family and property ties to Benton County. Dear Benton County Commissioners, I came to Corvallis in 1974 as a doctoral student in oceanography. My PhD led me to expand into the wider relationships between living creatures and their environments. I note the ongoing realities in the current debacle around waste management in this part of Oregon, as well as many parts of the earth. Siting dumps in high rainfall areas and wetlands is highly inappropriate. The eastern part of Oregon has habitat far more accommodating to effective stewardship of many kinds of waste. The leachate in wet areas moves far and wide, and it's far easier to manage in dry climates. Continuing to pile up more waste that arrives from other wet areas only exacerbates the difficulties and increases the hazards for those who live in the area. When other more suitable locations readily exist, allowing Coffin Butte Landfill to expand is irresponsible and unduly burdens residents of all species and the environments in which they live. Benton County has been targeted for quick fixes and lack of accountability toward the human and other creatures in this area, particularly when waste is collected from a far larger area than Benton County itself. It is not only unjust, but bad science. The latter part of my career moved me into justice work across the world as the presiding bishop of the Episcopal Church. Today, this community includes 21 nations and territories linked with the worldwide Anglican Communion, the fourth largest Christian communion in the world. All peoples of faith are called to seek justice for their own people and their neighbors far and near. The realities in Benton County are the result of venality and lack of caring for other people and creatures. Most of us would call it sin. We have been created to care for our neighbors as we would ourselves. Respectively, the Right Reverend Catherine Jeffert Shorey, PhD. And on to my own testimony. I'm the mother of 3 young children who have lived in Adair Village and now live in Soap Creek Valley. All 3 of them have lived under the shadow of the landfill since infancy. I'm speaking tonight to implore that you deny LU-24-027 with arguments below showing that this application does indeed seriously interfere with safe use of adjacent properties and places undue burden on public facilities. I have a degree in civil engineering from the University of Portland, where I studied transportation engineering, drinking water and wastewater treatment, and the Coffin Butte Landfill specifically during my solid waste management studies. I have a master's in public administration from the University of Oklahoma, during which I studied community leader ethics, among other topics. I was an evaluator pilot in the US Air Force, where I was responsible for the safety of 40-person crews, which along with requiring specific flying expertise included many emergency training situations. My paid profession for over 10 years was literally to keep all aspects of potential scenarios in mind while preventing my airplane from crashing, ensuring the safety of those on board and on the ground below us. Whether in the air or on the ground, I was specifically charged with the safety of the subordinates under my leadership. You have been voted into your positions by the citizens of Benton County with the charge and responsibility of focusing on and ensuring the health and safety of those same current residents and a follow-on responsibility to all future generations who will live in Benton County. As you heard last night and earlier tonight, once waste is placed on the south side of Coffin Butte Road, it will statutorily be very simple for Republic to close that emergency egress route without any public involvement. Please see my attached letter for additional details. Since the landfill was not even considered in the most recent Community Wildfire Protection Plan, you have no basis with which to state that you can safely close Coffin Butte Road as an emergency egress route. The only way for you to ensure that our primary egress route remains a viable option, unless until proven otherwise, is to deny this expansion application. Approving LU-24-027 seriously interferes with and places an undue burden on the safe use of adjacent properties and public facilities, including the safety of all current and future residents of Soap Creek Valley and Tampico neighborhoods during wildfire, earthquake, or other emergency egress situations, because we will no longer be guaranteed that this road will not be closed by future persons responsible for the landfill or employed by Benton County. The sitting commissioners, as of October 2025, are solely responsible for ensuring this egress route stays open in perpetuity. Please embrace the faith and responsibility that the current residents of Benton County have placed in you when you make your decision on this land use application. A little history on the site. A letter was written to the Benton County Planning Commission on November 5th, 1973 by the North Benton Citizens Advisory Committee, as discussed earlier. Just over a year before my husband was born and came home from the Old Good Sam Hospital to his house in Adair Village. That letter emphasized that this landfill was never sited in an appropriate location and urged then commissioners to not allow this landfill to expand. Another decision in 1983 to allow landfill activities to occur on the tax lot south of Coffin Butte Road, again specifically stated that waste would never be deposited south of Coffin Butte Road. Time and time again, citizens have had to fight back against the elected and appointed officials of our own county who are supposed to be taking care of our health and safety in order to protect our investments and the health of our families. I will now address some health and safety concerns with groundwater and leachate. As part of my Air Force career, I lived near a lake on the south side of Oklahoma City, which was our drinking water source. There have since been whistleblower accounts of contaminants leaking underground and flowing toward the lake. I was one of 4 women who I knew who lived near the lake who experienced multiple miscarriages while living there. All 4 of us then moved to an Air Force base in Anchorage, Alaska, and all went on to have multiple successful pregnancies. I probably won't ever know if that lake was the culprit, but I do know that toxic leachate is and has been dumped into the Willamette River just upstream of Adair drinking water. Has the Oregon Health Authority or Benton County Health Department been part of this discussion? Has anyone researched the cancer clusters in Adair Village or Soap Creek Valley? I've heard reports of a medical provider in town noting multiple women who live in Adair Village having thyroid issues. Can you tell me that the proper health authorities have been part of this process to ensure we are not already being poisoned and that an expansion won't add additional burden to the health and safety of your constituents? Last night, we heard from Pat Hare, assuring us that Adair Village's drinking water meets all standards. I do truly believe that Adair Village's drinking water meets all current regulatory standards. Unfortunately, those standards do not include standardized specialized testing for PFAS and other landfill toxins. 2024 testing did not require testing for lead, synthetic organic compounds, arsenic, or asbestos, so we don't have a current record of impacts from the increasing amount of leachate entering the Willamette. So unfortunately, I think this is a case of, quote, following the rules does not necessarily equate to safety due to outdated regulations. The 2022 and 24 Adair water quality reports are attached to my written submission. For years, I've been asking why Republic has not offered Adair Village more extensive testing, which they very well could afford. If they really thought it was safe, I would expect them to offer the tests to prove that drinking water was indeed free of concerning contaminants. The data seem to have a vacuum in this department. Who has tested the water in the fishing pond in E.E. Wilson? This pond is specifically stocked with fish every year for the purpose of recreational fishing. Within the last year, I watched a family with 8 or 10 large fish on a line walking back to their car. I know no other purpose of carrying a large number of dead fish to your car other than to take them home to eat. What about the health and safety of this family? There's a creek that drains directly from the settling ponds on the north side of Coffin Butte Road under 99 and directly to that pond. Who has confirmed that allowing fishing to happen at that pond is safe and not indeed poisoning the families who consume the fish from that pond? These speculations are critical to consider, because if you approve this expansion now, there will be no recourse for the increasing impact on the community if Benton County Health Department or OHA do find negative health outcomes for the families impacted by the air and water contamination due to this landfill. On to consent. There has been a lot of discussion about teaching consent to children these days, even down to something as seemingly small as giving consent to get a hug. In these discussions, children are taught that no means no. No can mean, no, I don't want a hug. No can mean, no, I don't want to share my drink with you. No means the same in this context as it does in an elementary classroom. No, this landfill is not in a good location for expansion. No, this area was never a good location for landfill. The citizens of Benton County have known for well over 50 years this is not a safe or logical place to deposit waste. How many times do we have to keep discussing this topic before Benton County leaders will learn what consent means and that no means no? I will now address some arguments made by Republic's fire expert James Walsh and statements in the staff report. The meeting between Republic and Adair Rural Fire in March was explicitly about current emergency operations, and Republic staff started the meeting by stating that it was specifically not for discussing the expansion, which would explain why there was no discussion about potential burdens of an expansion. The firefighters very much want to keep a very good working relationship with Brock and the other operators, since they are all risking their lives during a fire. They must be able to trust and rely on each other during these emergencies. The discussion about burdens on the department are better suited to administrative, not operational discussions. Had staff or county consultants ever reached out to Adair Rural Fire, either in the previous set of hearings or in preparation for this hearing, they could have discussed these situations and received a better understanding of actual operations and burdens on the department. Within this application process, there have been ongoing discussion about property values and how that will ultimately impact the amount of property taxes paid, thereby the amount of property taxes that go directly to the Adair Rural Fire District budget. County staff state in their report, quote, "The expansion will have no impact on the Adair Fire Protection District's tax base," end quote. Last night, Petra told you that you cannot consider property tax implications on adjacent parcels, so stick with me here. Have you looked at the specific property taxes being paid by Republic? The two main tax lots north of Coffin Butte Road, where waste is currently being deposited, lots 801 and 1106, pay $221 and $211 per acre respectively. The lot north of the road with the settling ponds pays $233 per acre, and the lot with the screening trees pays $294 per acre. Did you know that the tax lot where the proposed expansion is currently paying $826 per acre? Can you tell us how the Benton County assessor assesses the value of each of these lots? Once trash is placed on a lot, it appears the current assessed value is approximately $216 per acre. That tells me that in perpetuity, tax lot 1107 will now only pay a quarter of what it has been paying, which will directly impact the amount of money going to Benton County Public Services, including the Adair Rural Fire Protection District. The other argument pertaining to property values is that the landfill has been here for 70 years, according to the staff report. Those properties that are currently adjacent to the landfill have had that designation for a long time, and the staff reports that, quote, "An expansion will not change that situation," end quote. The landfill where waste has been deposited is north of Coffin Butte Road. There are several tax lots south of the proposed expansion that could be developed for multiple house sites, including that owned by the Kipper family. I understand that Petra stated you can't consider potential future uses of adjacent land, but your constituents have made large family investments based on previously written decisions by prior county leadership about promises of future uses of the landfill tax lot south of Coffin Butte Road. So if you can't consider future uses of other people's land, please at least stick with the prior decisions of county leadership, like the decision in 1983 that clearly defined that waste could never be placed on the lot south of Coffin Butte Road. The staff report also discusses the current number of fire department volunteers addressed by the fire district, and that because the department did not declare a minimum number of volunteers required, staff did not consider this point. Unfortunately, the point made by the department was missed. The point is that as the toxic air, unknown safety of water, fire risk, and investment risk to buying a home within the Adair Fire District all increase, it is potential that the number of people with the capacity to volunteer for the fire department will decrease and could indeed lead to an ineffective or closed department. This has dire consequences on the homeowner and fire insurance rates for all residents within the fire district. If the ISO rating were to drop from a 3 to a 10, all renters and property owners within the district would see steep insurance increases, which by definition would be an undue burden. Other arguments made by Jim Walsh is that the FEMA document referenced by Adair Rural Fire doesn't apply to the situation. He states about the document, quote, "It talked about risk of fire coming from debris piles associated with their emergency cleanup operations," end quote, and that, quote, "Sometimes that's called a landfill, but that's not a modern municipal solid waste subtitle D landfill like we have at Coffin Butte," end quote. The document that has been referred to is the FEMA document because the National Fire Data Center is a suborganization to the United States Fire Administration, which falls under the Department of FEMA. If you would please look at the FEMA document attached to the Adair Fire District letter, you will see that it's specifically addressing municipal solid waste landfills like we do have here in Benton County. The document states, quote, "Landfill fires are particularly challenging to the fire service and constrain a jurisdiction, particularly one dependent on volunteer staffing." In the rebuttal in front of the Planning Commission, Jim Walsh also speaks about methane being a fire concern, stating that there is, quote, "No history of that at modern municipal solid waste landfills, so we don't see the connection," end quote. That is entirely and utterly false. I will again point you back to the FEMA document in which it states, quote, methane is highly flammable and plays a large role in the ignition of landfill fires, end quote. So are you inclined to believe me, a non-firefighter, Jim Walsh, the fire expert paid by Republic, or this document produced by the US Fire Administration? I will leave that in your hands. I ask you to reference my testimony to the Planning Commission, which I resubmitted tonight, in which I discussed the spin doctor routine that Republic Services Public Relations team has placed on this whole process. I've included written discussion of false claims from Republic employees during the September DSAC meeting, but I won't read those into the record tonight. We have pointed out time and time again, omissions, untruths, and flat out lies throughout their application and other materials. Please review that testimony with a quick video reference as submitted tonight to your printed testimony table. And I urge you to consider whether you should approve this application when there's any doubt in your mind of the truthfulness of multiple parts of the application, supporting documents, and fake grassroots campaigns that they have used the last 60 days to propagate through our community. I'm sorry to say that we only get 2 minutes per person unless seated to speak tonight so that we can stay on our timeline after Republic was just granted 60-day extension, not to fix methane problems, not to implement red flag watch duty, not to actually clean up the sides of the highways, but to try to buy off other local politicians to influence this process. Last night during their presentation, Republic is quoted to say, quote, if we get the approval, we know we'll have to clean up the arterial roads as well, end quote. Can I please ask why they did not undertake this task during these past 60 days, let alone the past 4 years? We've had amazing weather recently, which would have made trash pickup simple. We are expecting 2 full inches of rain in the next 3 days. I shudder to think how far and wide the roadside trash will travel in flooded roadside ditches. If Republic's experts were actually able to prove that this expansion doesn't place undue burden on public services or change the character of the area, they wouldn't have to spend all this extra energy, time, and money trying to buy votes, including recruiting elected and public officials from other jurisdictions to come and weigh in on your county's process. Nobody is paying us to come up with our research or sacrificing thousands of hours, loss of paid work time, and loss of lots of work on our properties and with our children. Even without well-funded offices or deep coffers, we have been able to prove so many adverse effects, it's not even funny. Republic has continued to blame the people who bought land adjacent or nearby to the landfill decades ago. Residents purchased land under the promises of past county leadership, saying this landfill would close a number of times and that it would most definitely never have trash placed south of Coffin Butte Road. Yet Republic continues to point at these trusting citizens, saying that we are getting what we deserve. Commissioners, you chose to run for these positions. So to follow that line of reasoning, unfortunately, you're getting what you deserve, and now you're holding the responsibility of this decision in your hands. You were elected by a large number of people in this county who put their trust and faith in you, that you would take care of our health and well-being, and now is your chance to make good on that promise. You were not elected by Republic Services, but instead by the citizens of Benton County, who are still putting their faith and trust in you to see this landfill for what it is, a health, safety, and environmental liability that never has and never will be sited in an appropriate geological location. Please don't fail us now. Thank you, thank you, thank you for your tireless efforts considering this matter. I know it has taken a lot of time and energy. Thank you.
Thank you, Ms. Harris. One small, please, if we could maintain courtesy. I do have one quick question. I just want to make sure that you are not saying that you believe that Republic Services has paid other elected officials to support this. You're not saying that, correct?
I'm not
Okay,
saying
thank you
they
very
have
much.
paid any elected officials.
Okay,
But
thank you.
that they have spent time and money with this grassroots campaign. So
Thank
not
you.
that they gave money.
Thank you for
to-
clarifying. I think now in just a minute will be a good time to call for a break. I did want to go back in time for just a moment, and I meant to ask the elected officials here if we had any additional new ex parte contacts to declare since yesterday.
None since our last meeting for me.
None.
Thank you. Any new bias or conflict of interest to report?
No, none for me.
Not since yesterday.
Thank you. None for me either. Okay, and with that, we will take a 5-minute break. So let's come back. We'll come back at 6:55. As soon as everyone is quiet, I can call for the next three testifiers. The next three are Emily Wells, Bruce Cowger, and Kiko Denzer. Do we have Emily Wells with us? We don't have Emily online, so I'll ask one more time as we're all getting settled. Is Emily Wells in the room? It is your turn to testify. Okay, been there. Next up, we have Bruce Cowger.
Commissioners, good evening. Thank you for the opportunity to speak. I am Bruce Cowger. I live at 37194 Helm Drive in Corvallis. My wife Donna and I have lived in Soap Creek Valley, about 5 miles southeast of the landfill, since 1985. This is where we raised our children. I have degrees in physics and mechanical engineering, and for many years made a living by deeply understanding the physics of interactions between air, solids, and water-based liquids. Otherwise, this is known as inkjet printing. I'm concerned about the ongoing airborne emissions of PFAS, so-called forever chemicals from Coffin Butte. Let me start by briefly backtracking. By the end of the Manhattan Project in 1947, DuPont had learned how to make PFAS in volume and began searching for ways to commercialize nonstick coatings. Shovels, cookware, who hasn't enjoyed using nonstick cookware? There would be little worry about the risks to human health if PFAS were always formed as extremely long carbon chains with 2 fluorine atoms on each carbon. Ingested, such molecules would pass right through us. Unfortunately, companies like 3M, DuPont, and Chemours have also produced and continue to produce fluorosurfactants, more compact molecules of 6 to 10 carbons. Remember Scotchgard? These fluorosurfactants are far more mobile than long-chain Teflon coatings on your fry pan. Not only are they more mobile, they are readily absorbed by humans and animals due to their similarity to fatty acids, which our bodies use to produce energy. Worst, fluorosurfactants readily accumulate in our bodies and lead to cancers of the kidney, testicle, and breast, as well as reduced antibody response and low fetal weight, among other risks. Please see the paper by Pan and Liu, that's L-I-U, attached to my written testimony of October 5th. How much fluorosurfactant is inside us right now? About 6 parts per billion is the average across the US. 2 parts per billion is generally regarded as low risk, while 20 parts per billion is high risk. So we're somewhere in between on average. And while we don't live next to a military base, we do live next to a landfill. Much of the PFAS in Coffin Butte are fluorosurfactants, and sadly, because these little 6 to 10 carbon molecules are so mobile, they're not staying in the landfill. You have written and verbal testimony about PFAS in the millions of gallons of leachate produced each year at Coffin Butte Landfill. Leachate is the downward escape path for landfill pollutants. But what about upward flowing aerosols carried out by the unending flow of decomposition gases, CO2 and methane? In the written testimony I submitted on October 5th is a summary of a 2024 paper by Townsend and Lynn, finding that air emissions can carry PFA quantities comparable to those borne by leachate based on tests of actual US landfills. Wow. All these surfactants are being wafted by the prevailing winds a lot further than a quarter mile until they settle. Whether you inhale these or they land on your skin or the produce of your garden, they're readily absorbed and accumulated. The Coffin Butte landfill is thus a point source of PFA air pollution, risking the health of residents in Lynn, Polk, and Benton counties. It is terribly unfortunate that the 2020 franchise agreement for Coffin Butte landfill is completely silent on the topic of PFAS. No monitoring, no reporting. Who signed off on that decision? Today, residents are counting on you, our elected officials, to safeguard our health. We very much need you to pursue the goals stated in the county's comprehensive plan of maintaining and improving the quality of air, water, and land resources of the state. What can Benton County do to mitigate this air pollution? It is impractical, frankly, to sort out all the fluorosurfactant containing rubbish, as these chemicals are ubiquitous in municipal, industrial, and construction waste. Can such waste be separated from the landfill gas that conveys PFAS out into the air? Not economically. What about flares? Yes, flares are useful for reducing the methane release into the air, but at a maximum temperature of 850 degrees C, they simply aren't hot enough to mineralize PFAS. What else can be done? Airborne PFAS are propelled by landfill gases, and landfill gases are generated by the decomposition of organic matter in the presence of water. As it's similarly impractical to eliminate organic material from Coffin Butte, one is left to question if water in landfills can be minimized. And once you contemplate that, it becomes crystal clear that landfills need to be sited in drier locations than Benton County. This is great news for Benton County, for you, the commissioners. Why? Because there is a large and seemingly well-run landfill in Gilliam County, about 200 miles northeast of us. With only 9 inches of rainfall on average, the Columbia Ridge landfill produces, that's my 6 minutes?
I believe so. Yes,
Oh.
thank you. If you would like to.
Thank you. Okay, the Coffin Butte, the Columbia Ridge landfill produces so little leachate that they simply recycle it as a dust control measure. 2/3 of Seattle's municipal solid waste travels the 300 miles by rail car to Columbia Ridge. I strongly encourage Benton County to first deny the expansion of Coffin Butte and then set about planning the transition to waste disposal at Columbia Ridge as soon as possible. Yes, I know you've been told not to consider this, but the importance of our health compels me to offer this testimony and make this request. By the way, to all those stoking fears about higher garbage collection fees when Coffin Butte closes, garbage fees in Seattle are only slightly higher than in Benton County. Look it up. Commissioners, please stand by our county's comprehensive plan and minimize the pollution from Coffin Butte. Thank you.
Thank you. And I believe you only used 1 minute of your time. So if you'd like to have 3 minutes, we'll do that.
3 minutes, perfect. Good evening. Gabe, Nancy, I've met you before. Mr. Malone, I haven't had the pleasure yet, but glad to see you here tonight. My name is Kiko Denzer. I live at 928 North 9th Street in Philomath. And I've submitted some written testimony. I wrote some out for tonight, but frankly, the other testimony far outweighs anything I have to add. I'm not an expert really in anything except my own life, which has been pretty small. I'm a cheap SOB. My average annual adjusted gross income is $8,000 a year. I raised a family on that. And I'm proud. Part of the reason I could do that is because I generated very little waste and never paid collection fees. And I've been to the dump, I don't know, 3-4 times. I did some renovations, had to take a couple of pickup truck loads, and I save up my trash. And when I have a large full box, I throw it in the truck and I go to the dump. It doesn't happen very often. I'm appalled at what I've heard here and that we are sitting here talking about this expansion. My one question to you guys is, did you guys take an oath of office?
Generally, it's not a time for back and forth and questions of the commissioners, but yes, we did.
And I assume that oath of office included the Constitution of the state of Oregon.
Correct.
So I looked it up, and the Constitution says, no law shall in any case whatever interfere with the rights of conscience. This, to me, is an issue of conscience. We live in a world that is being destroyed and degraded every day by activities that we know we undertake. I'm guilty like everybody else. I travel in a car, I've traveled in airplanes, I generate waste, I do all this stuff. But I have choices about how much of that stuff I do, and I try to minimize it. I can't believe that we're not trying to minimize this, both as corporations and as citizens. Corporations are also citizens. And the fact that we are making money by poisoning the ground and the water is absolutely appalling and outrageous. I was going to talk about adjacency because I like words and I like definitions, but frankly, the methane plumes make Coffin Butte adjacent to every landmass on the planet because that methane travels, and the methane and the water both generate the weather, and the weather affects everybody on the planet. So the advice, the expert advice that you've been given seems to me false and misleading. But I'm grateful for all of your work and for the work of all the volunteers who are here. Thank you very much.
Thank you. Next up, we have Mason Leavitt, Pam Castle, and Debbie Palmer.
Thank you, commissioners, for allowing me to speak here today. My name is Mason Leavitt, and I'm testifying on behalf of Beyond Toxics, an environmental organization based at 120 Shelton McMurphy Boulevard.
One moment. Please continue.
Beyond Toxics is a membership-based organization, meaning we speak on behalf of our 13,000 members, which includes residents in the Soap Creek Valley and Adair Village adjacent to the landfill, even by the overly restrictive definition that the applicant has proposed tonight. I am trained in GIS and spatial data science. This is similar to data science, but with an added element of place-based context. And I have worked on a variety of research projects on land use planning with the U of O Law School, U of O School of Planning, Public Policy and Management, and the Department of Geography, in addition to the Portland-based land use firm Eco Northwest and Waymo, Google's autonomous vehicle division. I am currently in the process of getting a master's degree in the field as well. I have been working as a representative of Beyond Toxics with the neighbors of the landfill since August 2022. Our goal as an organization is always to investigate and solve the multitude of environmental and public health challenges posed by large industrial operations. As an organization, we are conscious of the need for waste management and how important it is for the economy. However, not all locations are fit for the siting or expansion of a landfill. After years of research, Beyond Toxics is confident that Coffin Butte is a disastrous location for a landfill. And as a result, we have shared many cost-effective solutions achievable in the 14 years of capacity currently remaining at Coffin Butte. The wet climate and the local geology pose an enormous undue risk on Oregon's natural resources, the people living nearby, and all who rely on the Willamette River. Most importantly, no landfill should ever be located close to suburban or urban population centers like Coffin Butte Landfill is. The nature of this site and the local geography inevitably make it difficult, if not impossible, to meet the land use criteria laid out in Benton County Code and the comprehensive plan. The environmental conflicts that harm local public health are well documented and in the record, and an expansion exacerbates them in two ways. One, the scale of these problems increases with the size of the expansion. And two, the duration of these problems also increases. This forms the key reason why looking at Coffin Butte's current record of impacts on residents and overall compliance with environmental regulations is so important. In an eerily similar case on the expansion of Riverbend Landfill in McMinnville, the Oregon Land Use Board of Appeals explicitly stated that the only viable way to evaluate the impacts of a landfill expansion is to look at the current operation. The applicant's current operation is actively under independent investigations by DEQ and EPA for potentially violating Oregon landfill gas rules and the federal landfill gas rules, respectively. EPA conducted a series of announced inspections in 2022 across landfills throughout the United States, and Coffin Butte was just one of those. EPA's inspections for Coffin Butte came less than 20 days after a public service's own monitoring, and after monitoring only a small portion of the landfill, EPA found 71 leaks, several of which were explosive concentrations. If you look at Exhibit 12, page 4, submitted by the applicant, you will notice a graph of leaks detected at Coffin Butte over time. And you will notice a short and sudden rapid spike of those leaks in June 2022 as a result of the EPA investigation. 40 of those leaks were at locations with holes, tears, or gaps in their tarping, which are required to be monitored by Oregon law, even if the applicant claims those tarps are not meant for retaining landfill gas. EPA conducted a follow-up unannounced inspection in 2024 where similar issues were identified. EPA continues their investigation through a Section 114 information request to perform an audit of Coffin Butte Landfill. That is still in progress. No other landfill in EPA Region 10 has been served a Section 114 request as a result of the random inspections conducted in 2022, which sets Coffin Butte as unparalleled in their mismanagement of landfill gas as compared to their Region 10 peers. Senator Merkley, Senator Wyden, and Rep. Val Hoyle have all called for further investigation on this topic as a result. In addition to multiple enforcement notices for a 2-year delay in installing a closed flare at Coffin Butte Landfill in 2024, DEQ is now launching another investigation into the applicant's process of exempting an average of 76% of the landfill surface area from any gas monitoring over the year of 2024. In those 4 tests conducted over a year, in one of those 4 tests conducted over the year, Republic exempted 92% of their landfill from any monitoring for leaks of landfill gas. This is the single highest rate of exemption I have ever seen in any Oregon landfill in the 3 years I have been reviewing these compliance records. This is what I call the practice of no data, no problem. If there is no testing done, there are no leaks found. And if those leaks don't exist, they never get fixed. It's not just the EPA who's finding these leaks. Many of them are visible from space. Carbon Mapper is a research-based organization that conducts flyovers of methane-producing industrial operations, including oil and gas, power generation, caged animal feeding operations, and of course, landfills. Carbon Mapper installs instruments tuned to the spectral properties of methane aboard aircraft and satellites which fly over the surface of the Earth. Over 12 days of random observation since 2022, Carbon Mapper has detected 28 distinct super emission events or plumes, each of which have been quantified to be leaking 1 to 7.6 metric tons of methane. This would equate to 2 to 15.2 metric tons of total landfill gas leaking off the facility every hour. Many of these plumes extend well into Soap Creek Valley and Adair Village, well beyond the applicant's definition of adjacent tax lots. It turns out that landfill gas is not respectful of the artificial property boundaries defined by Oregon planners decades ago. And this highlights the over-reliance of the term abutting by both county staff and the applicant, when adjacent can also be defined as near. When Carbon Mapper detects a landfill plume, they also trace where that plume originates from. All of the areas where plumes originate from are areas that Coffin Butte has exempted from monitoring during all of 2024 and 3 out of 4 monitoring periods in 2023. This data suggests a serious gap in the monitoring the compliance and effectiveness of the gas collection system. Why is this data from Carbon Mapper and the report submitted to the Oregon Department of Equality so important? There are 2 reasons. One, the consultant for the county has concluded that more gas collection wells will mitigate odors. The evidence regulatory agencies and the public has access to suggests that more wells are not currently solving the problem. So why should we believe they will work in the future? 2, the applicant's odor model assumes a collection rate of 75% of the landfill gas and 25% of the total gas is escaping in the form of fugitive emissions. This assumption is only true if the gas collection system is working. The evidence presented here strongly contradicts that assumption. Thus, the inputs of the model are no longer valid. We will turn to more of those later. The applicant has installed a total of 44 new wells from July 2024 to June 2025. You will often hear the applicant cite their recent installation of gas wells as a performance measure of tackling gas and odor problems. And it's the basis for the staff's assumption that odor will eventually be mitigated. Oregon law requires operators, in this case, however, the rate of well installation is an indication of the applicant's failing gas collection system. Oregon law requires operators to conduct follow-up corrective actions to leaks uncovered during monitoring. After a leak is found, an operator has 10 days to perform a corrective action and conduct follow-up analysis. If that doesn't work, they have an additional 30 days for another corrective action and follow-up. If that still doesn't work, the operator is required to install a new gas collection well within 120 days by Oregon law. The applicant often boasts their landfill has 3 times the industry standard in gas collection wells. Why would they spend millions of dollars of doing this? Why have they installed so many wells in recent years? It's because their limited monitoring and inspections by EPA have uncovered leaks showing their gas collection system isn't working as intended. As a result, they have been legally required to install far more gas collection wells than their peers. The evidence I have just gone over and submitted to the record strongly suggests that the applicant does not meet the requirements for the odor model. The EPA, DEQ, and Carbon Mapper have uncovered significant evidence that the gas collection system is not working properly, and the applicant's response to that has been to exempt 76% of their landfill surface from any monitoring. Instead of following the rules, the applicant has decided to throw the chessboard across the room. This has spurred DEQ to have to launch a follow-up investigation into this practice, as reported by the Statesman Journal September this year. I want to turn to the selected metric of the model, which is D over T. First, it's important to note that the threshold at which the applicant and staff have selected is the threshold at which an average person finds an odor to constitute a nuisance. I want to pause here on the word average. This means that half the population is dealing with the level of odor that constitutes a nuisance at lower thresholds. The measurement suggests the applicant poses a burden on 50% of the population below that D over T threshold. The D over T system has another critical assumption, which is that the smell is the only reason an odor constitutes a serious interference on an adjacent property. Not all smells are created equally. When I smell body odor, it might be unpleasant, but I'm not wholly concerned. When I smell wildfire smoke, I know I could be inhaling excess PM 2.5 and take additional precautions. When many people smell Coffin Butte, they know they are inhaling toxic fumes, including the yet to be regulated PFAs just discussed. The applicant and the staff have made an assumption that gases from the landfill are just a nuisance, nothing else. But that nuisance is exacerbated when people think of the potential health effects that they are encountering that are unknown to them, and that additional mental health burden poses a serious interference with the use of their property. So far, my testimony has bought into the applicant's assumption that modeling is the most effective tool to gauge the impact of odor. This can be contrasted with other tools like real-time air quality monitoring or surveying nearby homeowners. As the famous saying goes, all models are wrong, but some are useful. Models have fundamental limitations and they cannot and do not reflect all of the complexities of the real world. It is one tool in a series of tools in that toolbox. Even the applicant's consultants have acknowledged these limitations during planning commission hearings. Quote, models are not great at modeling surfaces that have complex topography, end quote. This is a questionable limitation given the complex topography of the area of Coffin Butte. They also stated, quote, models like this are not such that they track perfectly what we measure. These quotes nail a fundamental limitation of models. They do not reflect reality. I've demonstrated several reasons why the applicant's operations do not meet the basic assumptions of AirMod and LandGem, the two tools used to calculate emissions and their dispersal. The applicant's landfill gas collection system has glaring malfunctions and the monitoring system is designed to miss those leaks. Last night, commissioners found out that the applicant is using 20-year-old data as part of their model. This is the tip of the iceberg. I would like to address the input rate of 930,000 tons of municipal solid waste. Why isn't the applicant using their assumed intake of 1 million tons outlined as part of the condition of approval? What about the other 300,000 tons of waste? Just because it's not municipal solid waste doesn't mean there aren't organic waste capable of generating odors inside of that waste mass. What about the waste deposit on the north side? Recall the applicant has agreed we must consider the current facility's impacts when evaluating the potential impacts of the south. And if there are additional tons going into the north waste mass at the same time, this means it is likely that far more than 1 million tons will be going in. In the hearing for a Title V air contamination discharge permit with DEQ, the applicant stated they estimate they will have an intake of 1.5 million tons per year, which contradicts both of these numbers. And their own site plans in this application also project 1.5 to 1.8 million tons of waste per year. Why isn't the applicant's materials internally consistent? The applicant's model inputs are based on, this leaves the public with a single important question. What is the actual plan here? The lack of clarity obfuscates the parameters of the odor model and how they plan to comply with conditions of approval. I would also recommend you look at Ken Eklund and Nancy Whitcomb's testimony on this because they go into much more detail and further limitations I don't have time for tonight. However, there is also the question if the model is enough evidence on its own to show the applicant has met the burden of proof. You have seen and heard numerous testimonies that clearly demonstrate folks' smell levels of landfill gas that constitute a nuisance much further away than just the fence line of the facility. If a model does not reflect this reality and the inputs are not valid, this means the applicant model is still not an adequate reflection of reality and does not meet the burden of proof to demonstrate a significant burden is not occurring on adjacent land uses. As commissioners, you don't need to prefer one set of evidence over the other. If the applicant does not convince you that residential experiences of odor are wrong, then they have not met the burden of proof of disproving that. Finally, I want to observe again that the applicant has chosen not to deploy air quality monitoring as a technique for corroborating the findings of their odor study. The applicant has even submitted other odor studies done at landfills experiencing similar problems that do use air quality equipment. SCS Engineers, one of the consultants hired by the applicant, even strongly suggests using air monitors as an assured method to prevent odor nuisances on their website. Why are we discussing a model here when we could be dealing with real numbers? Remember, this is the same applicant that responded to EPA finding dozens of leaks by choosing not to monitor between 56 and 92% of their landfill. The Board of Commissioners has two different sets of data in front of them that leads them to different conclusions on the issues of odor. On one hand, the applicant has proposed an odor model whose underlying parameters are in serious question. On the other hand, there are hundreds of public testimony pointing to odor as an existing serious interference that will be exacerbated through both an increase in waste and an extended duration of the landfill. This is not anecdotal. This is a repository of qualitative evidence. The county has asked for testimony, and the quality of that testimony submitted is of incredibly high caliber, citing dozens of scientific studies, relying on third-party neutral evidence, and sharing heartbreaking experiences of serious interference on adjacent land uses. Based on the quality of the model submitted and the lack of serious engagement with regulatory filings and air quality monitoring parties showing the landfill does not meet the basic assumptions of modeling, one might conclude.
Thank you. That is your time.
Thank
Thank you. And let's maintain the rules of decorum so we can get through all the people that would like to speak tonight.
Good evening. Can you hear me? Yes. My name is Pam Castle, and I'm a Corvallis resident and live at 993 Northwest Cypress Avenue. Commissioners Malone, Shepherd, and Weiss, thank you for hearing this testimony and for serving on this board. It is appreciated. Today, I'm submitting, for the record, a people's testimony with the signatures of 1,250 community members who urge you to uphold the Planning Commission's careful decision to deny the application for the expansion of Coffin Butte Landfill. These 1,250 people recognize the significant environmental and economic burdens the landfill presents to Benton County, the Willamette Valley, and to Oregon. Although I won't be reading the testimony letter, I'll note that it speaks to the code that you must use in making your decision. It's not a piece of fluff, it's real testimony. What I do want to tell you about is how the community letter was born, how it grew its own legs, and why that's important. I think you will find it in stark contrast to some things that have occurred leading up to this hearings. In early September, Ken Eklund and I were talking trash with folks, as we sometimes do, and we were met with a frequent request, and that request was for something to sign. People wanted us to provide them with something that they could sign so that you know about their opposition to the expansion. You see, once people understand the problems with this landfill, they want to do something. But, and this is pretty important, not everyone is able to write testimony or speak at a hearing. Some feel too disenchanted and defeated by the process. Some don't feel capable. Some can't attend hearings. Some don't use computers, and the list is probably pretty long. Given this, we decided that they were right. A people's testimony letter really should exist. So Debbie Palmer wrote a great one. And I'll be honest that even though I thought it was great, I wasn't sure how it would be accepted in the wild. Maybe I would, we would get 100 signatures, something like that, a few people signing here and there. When Virginia Scott and I took it on its maiden voyage to a small event on September 14th, people were eager to sign, often sighing and expressing exasperation that this issue still haunts us. We often heard sentiments like, when will they take no for an answer? And why are we even debating this? It was at this event that I fully realized the level of disenfranchisement and disillusionment, I've used a lot of dis words, felt by community members. I had thought that maybe it was just me and the people around me that were closely involved in this issue that felt like the deck was stacked against them. These feelings are caused by many things. A lot of it by the lack of clarity in this process. There was also the issue of being intimidated by a multi-billion-dollar company scaring people about their trash rates and where their trash would go. The next day, on September 15th, my husband showed the testimony letter to some neighbors and got a few signatures as he took his morning stroll with the guys. And that's when something kind of extraordinary began. And I'm getting kind of emotional. It started when Les and Diana, gosh, weird, a neighborhood couple in their 80s asked if they could take it to their coffee clutch. And I said, sure. And then to their book club, and then to their exercise class. And I don't know where all it went because it was out of my hands for quite a while. Although they'd always opposed the expansion, they had never been involved with this issue before. Something in this letter struck a chord with them. Maybe it was partly a feeling of empowerment that they could do something, and partly that comfort that comes from finding people who share your worries and are doing something about it. This kind of scenario played out again and again, where community members kept the letter moving, engaged others in discussion about the issue. Then, in kind of a wild turn for me anyway, people began to hear about the letter and approach me to sign it. I'd be somewhere and somebody would want their friend to sign it. At the farmer's market, people were making purposeful trips to the table to sign it. And last Saturday, folks made a beeline right for the table to make sure their names were added. It's easy to focus on the large number of signatures, but it's important to realize that there's a real person behind each one. When I was numbering the signatures, I found myself remembering particular people out of the hundreds I've probably spoken with over the last 6 weeks. One of those was Elise, a girl of probably 10 years old. As Elise listened to her mother and I discussed the issues with leachate going to municipal wastewater treatment plants, she held up her hand in the most adorable fashion to contribute to the conversation. Her sincere and thoughtful insight about the broader problems with this practice of leachate distribution was pretty incredible. When her mom signed the letter, Elise asked if she could too, and I said, of course she could. We need caring, well-informed people like her on our team. So I ask that you remember Elise when you make your decision. She deserves commissioners who are as thoughtful as she is. What is important to know about all of these signatures is that they are the result of community members engaging with community members, standing on front porches and on sidewalks, sitting in living rooms, meeting with friends at cafes. It even went to a bridge group. They were not the result of an email campaign nor a text blitz, and certainly weren't collected online. This is what a grassroots movement is. It is organic and authentic. It is often unexpected. It is unscripted, and it tells you about your community. It tells you that people care. Now that the latest staff report seemingly discounts the vast amount of good, solid evidence against the expansion that was analyzed by the Planning Commission in making their thoughtful decision, people feel newly disenchanted. This was a frustration brought up to us by people we spoke with on Saturday. We have a creative, engaged community with extraordinary expertise in a wide array of topics. Yet the evidence they presented appears to be nearly dismissed in deference to the materials provided by the applicant's paid consultants, materials which were often easily shown to be demonstrably deficient. It is time to make sure that the voices of our community members are heard. On behalf of the 1,250 people who signed this testimony, I urge you to use your power of discretion to deny the conditional use permit to expand Coffin Butte Landfill. People like Elise are counting on you, so it's time to put a nail in this coffin.
Thank you, folks. If we could keep decorum.
Now, you would think I was done, but I'm not. But wait, there's more. So I have the privilege of reading into the record the opposition testimony submitted by Senator Gelser Bluen and Representative Finger McDonald. I have braces. So here it goes. Commissioner Malone, Shepherd, and Weiss. We write today to express our opposition to the expansion of Coffin Butte Landfill. Over the last several years, we've listened to constituents voice deep concern about the impact Coffin Butte has on the health, safety, livability, and environmental integrity of the surrounding land, the area surrounding the landfill. It is clear to us that the residents in the vicinity of the landfill are nearly unanimous in their opposition to expansion. It is not surprising to hear such concerns from people who live in close proximity to the landfill. For that reason, and because of the regional significance of the landfill, we've both listened carefully and been cautious about taking a public position on this application. However, we've learned what we've learned, combined with the well-financed effort to solicit input from elected officials outside of our area, led us to reconsider. We've both come to the conclusion that we must speak up for our constituents and publicly express our opposition to their application. Expanding Coffin Butte Landfill is not just an economic issue. It is an environmental, health, and livability issue, and at best, a short-term fix to handling solid waste in our region. We appreciate the legitimate interest of businesses and local governments outside of Benton County in the disposition of this application. Solid waste management is a thorny issue and one that requires focused attention from leaders and community members across the state. Coffin Butte has become the safety net for waste disposal for other communities. In fact, recent closures and diminished operations at other Oregon landfills and incinerators nearly doubled the amount of waste hauled to Coffin Butte each year. Sorry, I backed up. It's hard to see. The relief this provides to other jurisdictions and their citizens allows them to put off making hard decisions about waste disposal and comes at an extraordinary expense to our constituents, their health, and their businesses. While we appreciate the challenges faced by other communities, we simply do not believe it is fair or appropriate to force our constituents to continue sacrificing their health, livelihoods, and livability for the benefit of other communities. The consequences of landfill operations in Benton County directly impact the constituents we serve alongside you, the residents of Benton County. Benton County residents should be centered in the discussion and decision-making about this issue. Expansion advocates argue expansion is necessary to protect our constituents from increased costs related to solid waste. We've been told failure to approve the expansion will leave Benton County residents with no place to dispose of their waste without costly shipping across the state. This is simply not true. As you know, the county has the authority to determine any rate increases for waste disposal. In addition, the current franchise agreement requires Republic to accept Benton County solid waste through 2040. Denying the expansion may require Republic to make some tough choices, reduce hauling from other locations into Coffin Butte, or take on the cost of hauling Benton County waste elsewhere. However, that burden falls on Republic Services, a company with a total net income of $2.04 billion in 2024. Because Benton County residents are guaranteed waste disposal through 2040, there is no imminent risk of price increases or loss of disposal solutions for our constituents. Advocates are presenting the expansion of Coffin Butte as a long-term solution to our region's solid waste disposal challenges. However, with current disposal volumes, the expansion of the landfill will extend its life by at most a few years. If the expansion is granted, it is a short-term fix that will permanently alter the landscape of Benton County and extend the impact of dust, debris, and odor caused by waste dumping and truck traffic. The enormity of this impact will not be compensated for by a few extra years of life for Coffin Butte Landfill. We are surprised that expansion advocates are now arguing that HB 3794, legislation introduced by Representative Finger McDonald and sponsored by both of us, makes approval of the expansion application essential. The task force formed by HB 3794 will look at solid waste issues across the region. It anticipates the closure of Coffin Butte and the need to develop a reasonable, forward-looking waste management plan for our region. This is work that must be done regardless of whether the landfill is expanded. It is frustrating to see the task force work used to justify forcing the people of Benton County to continue disproportionately shouldering the burden of the Oregon's waste stream. Concerns of families and businesses in the vicinity of Coffin Butte have been repeatedly dismissed by expansion advocates who argue neighbors chose to locate their homes and businesses near a landfill. However, when the history of Coffin Butte Landfill is considered, the neighbors' concerns are clearly justified. The property started as a small community landfill and grew in spurts until its operations increased rapidly in recent years. Coffin Butte is no longer a local landfill. It is a large regional landfill. The yearly tonnage of waste accepted by Coffin Butte increased by 86% between 2016 and 2023. Its impact on neighboring properties could not have been anticipated even just a few years ago. Many of these neighbors moved to the area decades ago. If the landfill is expanded and the 1.1 million ton cap of waste Coffin Butte can accept each year is eliminated, the impacts that surrounding properties already experience, overwhelming odor, persistent dust, and the inability to graze livestock on long-time pastures due to plastics and particles that escape from the dump, will be exacerbated. The Benton County Planning Commission recognized these repercussions when they voted unanimously to reject the expansion proposal. We've been told by expansion advocates that objections are only coming from a small number of angry, disgruntled, and misinformed people. Our constituents are thoughtful, concerned, and deeply knowledgeable about soil, water, and environmental science. It is disappointing to hear advocates speak about our constituents with such disrespect. We are committed to long-term solutions for the future of waste management in Oregon. We are also committed to continued partnership with Republic Services to deploy innovative technologies to mitigate the environmental impacts of the landfill while it accepts waste and after its closure. We know there are no easy solutions. It will take creative thinking from people across all the counties that bring waste to Coffin Butte to map out a future for sustainable, fair, and safe strategy to manage the materials we discard. We also firmly believe that work does not require or justify an expansion of Coffin Butte Landfill. Denial of the expansion will not deprive Benton County residents of waste disposal site and does not have to increase disposal rates. Denying the application cannot undo the harm caused to our community by the rapid growth of Coffin Butte, but it can stop more harm from happening. We appreciate the pressures, the situation, and the complexity of the issues you must weigh in making this decision. That said, after visiting with proponents and opponents, conducting site visits, and studying the history of the landfill, we are both convinced that the harm done to our constituents by continuing to expand landfill far outweighs any short-term benefits of its growth. We strongly urge you to deny the application to expand Coffin Butte Landfill. Sincerely, Senator Sarah Gelser-Bluen and Representative Sarah Finger McDonald. And now you would think, oh, she's done now. And I'm saying, no, I'm not. So I haven't introduced any qualifications I have. So I have a master's degree in toxicology and taught college biology, genetics, chemistry, and organic chemistry for 20 years. That job required that I maintain a solid ability to locate and understand scientific literature in a wide variety of topics and be pretty up to snuff with them. And I wanted to talk about adjacency because I think that's the crux of this whole hearing. Adjacency in this context must account for the far-reaching effects of operating a landfill in this location. And I note the location because of the large amount of rainfall that Coffin Butte Landfill receives results in a large amount of leachate produced. Unless Republic Services is going to build a state-of-the-art treatment plant to remove PFAS, microplastics, heavy metals, and those kinds of things, they are not going to alleviate this burden on the community. They will continue hauling tens of millions of gallons of leachate to municipal wastewater treatment plants where these dangerous components are not treated or mitigated. They enter the environment via air, effluent to the Willamette River, or via biosolids applied to agricultural fields. The second problem with rainfall and too much organic material hauled to the landfill are difficult to capture bursts of landfill gas, which also contain PFAS and the greenhouse gas methane, amongst other things. The movement of leachate and landfill gas components offsite, sometimes far offsite, must confer adjacency to any location they reach. Way down in Corvallis, we smell landfill gas. It might be either the hydrogen sulfide, sometimes it smells sulfury, or solvents. Sometimes there's the sweet smell of dichloroethane or other unidentified volatilized components of landfill materials. This gives us in Corvallis adjacency. Anyone living near a field where Corvallis or Salem wastewater treatment biosolids have been applied has adjacency. Any abutting property to those also have adjacency. The PFAS, microplastics, et cetera, don't stay put. They can contaminate wells, surface water, and groundwater. In addition, biosolids can become airborne, carrying these toxic components with them. I submitted some testimony about dairies that were closed in Maine due to wells that were contaminated via this process of biosolid application. Now that Corvallis has said no more leachate at our wastewater treatment plant, and Salem appears to be heading that way, how far afield will leachate go? These are the burdens that go unaddressed by the applicant and the staff report. The staff report has always indicated that the application seems up to snuff, but has not brought on an expert on board to cast a critical eye on landfill gas and landfill leachate. We know regulatory agencies lag behind science. In this case, science tells us we should not be applying biosolids to fields, yet underfunded and understaffed, agencies are too slow to keep up. I urge you to expand the term adjacent to include those places bestowed adjacency by virtue of landfill effects. To do otherwise is incredibly unfair to residents and beyond and irresponsible. Thank you. There is no more.
Thank you.
Hi. Hi. My name is Debbie Palmer, and I live at 37340 Moss Rock Drive in Corvallis. And I'm going to make a command decision here to yield my testimony time, because I was going to talk about the concern of the toxic leachate leaving the landfill and the gas escaping and the things that were just covered by Pam. So in light of tonight's time, I'm just going to yield my time.
Thank you. We'll consider that as you agree. Next up, next three, we have Ken Eklund, Mark Hinkles, and Marge Pop.
I gotta lean into this microphone, don't I?
You might be able to scoot it closer. There you go. Or lift it up a little bit.
Perfect. Everyone hear me okay? Okay, great. Good evening, Chair Wise and Commissioners Malone and Shepherd. I urge you, commissioners, to let everyone speak. I have faith that the people behind me will get their turn, because I have faith that you will let everyone be heard. My name is Ken Eklund, and I live in Soap Creek Valley, 37340 Moss Rock Drive, Corvallis. I'm active in the community as a former participant in the Solid Waste Advisory Council, the Disposal Site Advisory Committee, and Benton County Talks Trash. I'm active on climate crisis issues, so let me direct you to the explainers that have entered into the written testimony, especially the one on greenhouse gases and the land use criteria. Several others as well on the EPA, on DEQ, and more. As the name suggests, the explainers intend to bring together and summarize what otherwise can be very scattered subjects. Professionally, I work in narrative design, most notably in future scenarios where I have an international following. Projects I've created have won awards, a couple of Webby nominations. Webbies are like the Oscars of the internet, and a special Peabody Award given for landmark contributions to storytelling. So I have cred in future scenarios work and in narrative. I'd like to tell you my origin story, how I got involved with a dump and its issues. It was 2020, and my wife and I went over to a neighbor's house because they had a library table that was looking for a new home. It was our first time meeting them. It being COVID time, we met outdoors. They had a very lovely yard, and I told them so. And they said, yeah, good thing it's not a dump day. We can't use our yard on a dump day. And I was surprised. They live closer to the dump than we do, but not that much closer. We're a little over 4 miles away. They're maybe 3. So that's how I first came to know for a fact that the landfill was leaking a lot of landfill gas. It takes a lot of landfill gas to make an odor plume 3 miles long. Nobody is going to say something like that about their home if it's not true. And this was in 2020, before anyone knew that the dump was going to try to expand. Fast forward to 2021, the Planning Commission hearings, lots of testimonies about dump days. Chair Ken Kennison asked the dump's environmental manager, Ian McNabb, about landfill gas emissions. How much is coming out of the landfill? Ian's response, it's a minimal amount. Commissioners, as we all know by now, it is not a minimal amount. But that's when I came to know that Republic's spin machine is on its highest setting all the time. Commissioners, I'm not speaking to you today to try to persuade you to deny this application. As someone who knows the importance of narrative, I think that ship has already sailed. I'm reading the same material as you and listening to the same testimonies. Viewed through the lens of narrative, I'm sure that you will deny. Because at the end of the day, you need to have a narrative that you can believe in. And there's really only one of those on the table. If you deny, the narrative about what happens is very straightforward. Everyone just continues doing what they're doing. Republic honors its various business contracts. Benton County gets its trash managed through the year 2040. A regional committee comes together under House Bill 3794 to gather evidence, hear all sides, and move the region forward into a more economically and environmentally sound plan for its garbage. The various investigation and enforcement actions currently underway against Republic by DEQ and the EPA proceed at their calm, thorough, and glacial pace. Life goes on. It's really hard for Republic to come up with a narrative that's better than that. So they haven't even tried. What they've done instead is to create a confusing scenario that's so huge and convoluted that it squeezes all the narratives out. The scenario they're asking you to sign is like the perfect storm of decision by committee. What's in it exactly? Do we know? Probably not. I don't think anyone does. How will it work? They left it for you to figure that out. It's a confusion, not a narrative. Commissioners, another reason that I know you will deny is this. A key part of what Republic's proposing is that Benton County government get into the environmental monitoring business. And you don't want to. It's a nightmare scenario, really. Republic commits an infraction and you take the heat for it, better get ready for a lot of heat. I can see why Republic would propose it, but I see zero reason why you would take that on. It's just not a venture that you will succeed at, and neither Republic nor staff have shown any evidence to the contrary. One salient example, the Community Concerns Annual Report that DSAC publishes every year. Community concerns right on target for this application. Not considered or not consulted or even considered by staff. Not consulted by Republic, and they're on DSAC. If you look at those reports, and you can, because the public put them in the record for you, you'll see hundreds of complaints about dump operations. And only one thing listed as an effective response to those complaints, the unanimous denial by the Planning Commission of Republic's application to expand. Again, if you deny, the narrative about what happens is very straightforward. Everyone just continues doing what they're doing. You stay out of environmental enforcement. Republic takes the heat for their infractions, not you. So I want to point something out here, which is that there's an established process for what's going on with this application, a process I'm very familiar with. This is future scenario work. Republican staff have worked together to develop a scenario in which the new landfill meets the criteria. The word tortured springs to mind. Let's take a look at it using the tools of future scenario planning. Boom, the scenario runs into trouble immediately because although they're building a scenario, they don't know how to build scenarios. I'm going to briefly mention 3 fundamentals of future scenario work that aren't present in the Republic staff approval with conditions scenario. The first one, you don't just develop one scenario. 2, you develop the scenario, you evaluate the scenarios you develop by looking for signals that they'll work. 3, you bring in as many viewpoints as possible because that's where you get signals from. Republican staff are pretending that there's only one scenario, which is the one they've laid out for you, commissioners. But as I've already made clear, there's clearly another scenario on the table, the one to deny. There are other scenarios as well, ones where approval with conditions actually runs into problems. I'll call those more real scenarios and get to them in a moment. But first you're wondering, does this relate to the land use criteria? So let me talk to that. The legal definition of burden of proof lists it as having 2 components, the burden of production, which is producing evidence, and the burden of persuasion, which is delivering a convincing narrative about that evidence. This is the legal definition of burden of proof. I'll include a variety of sources for it in the speech manuscript, but it's common sense as well. Republic can't just dump a pile of papers on the table and say the proof is in there somewhere. So Republic has a burden of proof, so they must deliver evidence and tell you a story about that evidence which you find convincing, or they fail their burden of proof, which is grounds for denying their application. I see this all the time in LUBA decisions and findings. We were not convinced by this, and we found this to be more convincing than that. You probably already know this because it's part of the discretionary power that you have in this decision. You know that ultimately you decide what terms like adjacent and nearby mean, and that ultimately you make the decision as to what is convincing and what has failed to convince. Because each of you individually are either convinced or you're not. I don't see how anyone can call the Republic staff scenario convincing. I don't think they do. Staff certainly doesn't. Their report focuses on whether it's complete from an evidence point of view, not on whether it will actually work. They're completely silent on that. They've kicked that upstairs for you to determine. Convincing, I think they avoid that word like the plague. And it's a core consideration in your deliberations and your decision, a core part of burden of proof to prevent serious interference, etc. Back to future scenario work. I'd mentioned signals and a wealth of viewpoints as other key elements of good scenario work. Signals is shorthand for signs in the present that the scenario will succeed. They're often explained by this quote from author William Gibson. The future is here, it's just not widely distributed. A signal is a bit of evidence that a scenario is already trying to happen. And you need a wealth of viewpoints because you need somewhere to look for signals. The Republic staff process has none of this. It's like the definition of an echo chamber. That became crystal clear when they brought their scenario out of the echo chamber and into the real world before the Planning Commission. It generated hundreds of pretty strong signals that their scenario was completely unworkable. It's too Pollyanna. The signals of that are pretty convincing. Again, Republic and staff have not provided you with any signals that their scenario would work. There's no evidence of that. It's completely theoretical. But as I said, there's plenty of evidence already in testimony and coming at you today that the scenario won't work. In the interest of time, I won't repeat any of that here. Instead, let me take up the thread of the other scenarios, the more real scenarios that come hand in hand with the Republic staff confusion scenario. Jeff Condit, Republic's attorney, set the stage for these yesterday, the case at the Costco in Salem. To recap, Salem permitted development of a commercial area after discussing and agreeing that there would be no Costco or other big box store in it, but they didn't put that into the permit itself. So when the landowner changed their mind and brought in a Costco, and they changed their mind and they brought in a Costco, and LUBA allowed that. LUBA basically said, don't believe promises, get it in writing. So how much of the Republic staff scenario is promises? How much of that application is promises and how much is it in writing? Basically, it's all promises. I'm talking now about the conditions of approval. Basically, it's all promises because it's all monitoring and no enforcement. There's no actual remediation going on in there. Commissioners, you hear and read a lot of testimony about that as well. Let me spin out a couple of these more reality-based scenarios for you. Let's pretend you approve the application with conditions. What happens next? 1, Republic changes its mind about the conditions of approval. Most or all of them in the Republic staff scenario never actually come to pass. The Board of Commissioners don't like this, but what can you do really? Invoke another conditional of approval? That will be ignored as well. 2, Republic changes its mind and immediately starts ramping up how much trash the dump takes in, well past their promise of 1.3 million tons a year. They get the new high volume by dropping prices to really low levels. They do that in a successful effort to derail the HB 3794 process and its desire to reduce how much trash the region generates. Once that's done, prices go back up. 3, Republic changes its mind and decides to prepare for the new landfill now and start digging a hole that's 150 feet deep in its deepest part, even before the appeal of their conditional use permit is heard at LUBA. 4, Republic changes its mind and decides to have 2 working phases at once. So in a few years, both the old landfill and the new landfill are filling up fast, and Republic is back with a new expansion proposal. The thing is, it's impossible for Benton County to protect itself in the region from these scenarios with conditions of approval, because Benton County has no viable way to enforce any condition of approval. Jeff Condit cited a relevant case where someone actually did enforce a condition of approval, which only goes to prove what I'm saying. That case took 8 years and millions of dollars. The only way for Benton County to succeed with conditions of approval is not to go down that road at all. Commissioners, there's nothing but tears for us down that road. So I'll say again, 2 scenarios. 1, the deny one that has been developed the way that scenarios should be developed, in the open, lots of dialogue, lots of consensus. If you deny, everyone just continues the way we're going. We execute on the plan. The HB 3794 Regional Committee comes together, and together the region moves forward with a more economically and environmentally sound plan. Life goes on, and Benton County is a guiding force. The other scenario has been developed in the way that scenarios shouldn't. Behind the scenes, no dialogue, no consensus. If you approve with conditions, you've hung Benton County's hat on conditions of approval that have no history of being enforced and are all monitoring and no enforcement. So it effectively means that Benton County has lost control over Coffin Butte Landfill. You have signed something and really have no idea of how it's going to go. Let me spin out another version of the approval with conditions scenario for you, a non-extreme one in which Republic Services doesn't change its mind about anything. You sign on to approve with conditions. Republic says, thank you very much, and shows your signature to its shareholders, who are very happy to see it, and then puts your signed approval in its back pocket. Life goes on. The dump continues to cause dump days, and the crisis over what to do with leachate continues to deepen. The bad news about PFAS continues to pile up. Republic continues to battle the EPA and DEQ on compliance. The trash continues to pile up on our roadways. But now there's that condition of approval in Republic's back pocket, and the residents of the entire area know it. It's sitting there like a time bomb. We know that something big and bad is going to happen, and so does Benton County government. How big and how bad, no one knows. But people make their decisions accordingly in proportion to the risk. When you smell the landfill, that's the smell of defeat, because it's not going to get better. It's going to get worse. You can hear the time bomb ticking. You make your decisions accordingly, and those individual decisions start to pile up. Commissioners, I think that's the very definition of serious interference with the character of the area. And I wonder how you would feel if some previous commissioners had put such an arrangement in motion so that during your term, it would become your responsibility to protect your community using conditions of approval that are all monitoring and no compliance, and set them the task of making those conditions work with Republic Services, who are now people who did not participate in drafting those conditions of approval, have no skin in the game, so to speak, and thus may see them as an unwelcome imposition to be subverted at every level. I think the provisions in land use code that charge you with guaranteeing no serious interference with the character of the area and no undue burden on public services were written to give you clear direction, not to cause the events I've just described, as was your oath of office. Note that in this very realistic scenario, we haven't even gotten to the landfilling yet, and already approval with conditions is spinning the situation far out of county control. Commissioners, Chair Wise, Commissioner Malone, Commissioner Shepherd, I realize that a little tone has crept into my voice, and I'll relax that now, because like I said, I'm pretty convinced that you're going to deny. Let's look underneath all this confusion at Republic's actual narrative underlying this application. The quiet part they won't say out loud. It's this, that Benton County continued to be the region's trash can. Right now, if Republic steps on the pedal, Benton County opens its lid. The narrative, if you deny, changes all that. The narrative, if you deny, signals to everyone in the waste shed that those days are over, that we have to find a better way forward together. Republic's application is first and foremost an attempt to stop that signal from going out. Please, commissioners, send that signal. Let's solve the trash problem, not expand it. Let's stop kicking that can down the road. Thank you, and I'm happy to answer any questions.
Thank you very much. Next up, we have Mark Henkels. One second, one moment, please. Changing a battery.
Hello.
Okay, there you go.
Okay. Hey, thank you for your attention. Thank you for all your commitment to this. I'm Mark Henkels. I'm a resident of 7540 Northeast Pettibone Drive, Corvallis, Oregon. I appreciate your hard work on this. 4 major points. First, the staff report seems designed to find ways to make the expansion potentially acceptable rather than considering whether it is a good idea to begin with. It reminds me of how some Tri-City officials once argued that the banks of the Columbia would be a great place to put the nation's high-level nuclear waste with proper engineering. The staff report has a pattern of noting problems, presenting 2 sides as being relatively equal, then recommending a condition that justifies the expansion. This approach minimizes the problems or risks by assuming that the proper required conditions will readily solve the problems. For example, the problem of litter appears easily fixed by adding another bull fence and more litter pickup. Neighbors observing trash flying high in the air might disagree with that litter is so easily contained, or that the burden should be on them to call for cleanup and trust that it will happen. Likewise, by the time monitoring wells identifies leaks, by the time leaks are identified by the monitoring wells, it is likely to be too late to stop the harm. This is geology, not indoor plumbing. In the early days, Valley Landfill bought nearby properties with problematic wells. Coffin Butte's hydrological footprint will be much larger, as is the volume of waste. Buying E.E. Wilson is not so simple should contaminants flow to the east. And it is notable that the U.S. Geological Survey concluded in a study that all landfills will leak eventually. The citation's in my submitted testimony. Your decision should reflect what is simply best for the county, not whether the expansion's issues can be theoretically addressed. Second, Republic Services use the term speculative when discussing opponents' concerns over conditions of approval. The current failure of federal and state governments to enforce laws, of the county to enforce COAs, of Republic Services to meet local expectations cannot be ignored. It is speculative to assume that the COAs will work as the staff report asserts. For example, the reliance on self-reporting or self-regulation in the past has been a true problem. I personally experienced how reporting an odor hit a wall when the state said Republic Services denied there was an odor problem that day. I and others know what we smelled, and I live 7 miles away. Also consider how both state and federal officials found methane leaks that far exceeded those Republic Services self-reported. And there still has been no definite or final state or federal action regarding those leaks. The staff recognizes, I quote, Benton County does not have staff resources or expertise to evaluate whether proposed conditional use complies with state and federal air and water quality standards. So are we to trust the federal government permitting process in the Trump era? And the state's plate is overflowing already, especially as we head towards recession. We know Republic Services has plenty of resources to lobby and litigate. Denying the expansion is the only way the county can control what happens next. 3, the assertion that the expansion does not change anything since the landfill already exists is unacceptable. A vibrant nature refuge, operating agriculture, citizens who enjoy where they live on non-stinky days, and some lovely vistas still define the character of that area. The expansion will greatly expand the surface area that will leak methane, be affected by runoff from freak intense rains, and be vulnerable to fire and other unpredictable events. More underground hydrological systems will be in play. Risks related to PFAS, methane, and other gases and chemicals can only increase. Yes, the existing dump is an ugly wart on the landscape that can be seen from Seward to North Albany already. But the expansion will greatly broaden that ugliness and bring the associated problems closer to Adair Village, Soap Creek Valley, and all North Corvallis. 4, the law gives you discretion to interpret the key phrases such as adjacent, undue burden, seriously, and my personal greatest concern, character of the area. Lawyers are not neutral experts. They serve the interests of their clients or their own personal goals. So long as you are reasonable, you owe no deference to any particular lawyer's interpretation of the law. You are purposely given the power to apply your own judgment of how the waiver would affect the county and how to apply the law. Republic Services is just getting started in the quarry section. It is well documented that the existing facility will last 12 to 14 more years. It is not closing tomorrow or in 5 years. The concerns of Newport and other jurisdictions deserve attention, except maybe Yamhill County, since it recently closed its dump and is happily using ours. Okay, but heed the pleas for a regional solution. Let's start planning now for better alternatives rather than simply continuing what's convenient today. Lane County has taken serious steps to reduce its landfill waste. Gilliam County demonstrates why we should consider moving our waste to a properly sited landfill. Alternatives to transporting waste are emerging. Expansion only enables us and places like Newport and Washington County to avoid what's doing right. We have treated Coffin Butte as a bottomless facility, as have other counties that contribute 92% of the waste filling that space. But each load carries an immediate price and long-term risk for all of us. Benton County alone bears those harms and risks. This is time to set the limit.
My mic, oh, there it is. Thank you. Next up, we have Marge Pop.
My name is Marge Pop, and I live at 1435 Southwest Birdie Drive in Corvallis. On June 13th, 2023, this board unanimously accepted the findings of the BCTT work group. Findings that remain clear and relevant today. First, Coffin Butte has at least 14 years of capacity, permitted capacity remaining. There is no immediate need for expansion. Second, the county has full latitude under its own code to interpret ambiguities and deny this expansion. And you have been presented with more than enough evidence during this hearing to do so. The decision belongs to you, not to Republic Services and not to staff or council who would defer to them. Your constituents, your planning commission, and now your state legislators, Senator Sarah Gelser-Bluen and Representative Sarah Finger McDonald, have all spoken with one voice. Expansion would trade permanent environmental harm for only a few additional years of landfill life. Your legislators' letter of testimony makes this explicit. Denial will not deprive Benton County of disposal options. Republic is contractually required to accept our waste through 2040. The burden of adaptation belongs with the corporation earning billions in profit, not with Benton County residents. Our legislators' letter also covers HB 3794, a bill they sponsored, which became effective on September 26, 2025. The bill establishes the Task Force on Municipal Solid Waste in the Willamette Valley to study solid waste options in our region. This is the beginning of a regional process that will use the next 15 years of landfill life to forge solutions for managing solid waste across the Willamette Valley. It anticipates the closure of Coffin Butte and the need to develop a responsible, forward-looking waste management plan for our region. You are being pressured to manage Republic's business problem, but you were elected to protect the people of this county, not Republic's balance sheet. This is not about need. It is about Republic protecting market share at the expense of our community. The 2040 Thriving Communities Initiative calls on us to ensure vibrant, livable communities, high environmental quality, and community resilience. Approving this expansion would violate every single one of those core values. HB 3794 has already set in motion a regional planning process for the post-Coffin Butte era. The responsible work is underway. Expansion would preempt it. Commissioners, you have both the authority and the moral responsibility to act in alignment with your community, your legislative partners, and your own adopted vision for a thriving Benton County. Please deny this application.
Thank you. How are we doing for a break? Okay, we are going to call for a break. 5 minutes, 10 minutes?
Sure.
5 minutes. Come back at 8:30. Fine. Fine. All right, and it looks like Marcus Harris is ready to go. Welcome.
Hello, Chair Wise and Commissioners. My name is Marcus Harris and I live at 37268 Moss Rock Drive. I am 11 years old and I am here asking you to deny Republic's request to expand our landfill. I moved to Adair Village when I was 9 months old. My younger sister was born a year later. When I was about 3.5, we moved to a house 40 miles south of Coffin Butte Landfill. A year later, my younger brother was born. We have lived there since and go to school in Adair Village. I'm here today to talk about Coffin Butte Landfill and how it affects our community. We do not know what is in the stink that the dump produces. I can smell it at my house and some days and sometimes at school. My mom will not let us play outside if it is stinky, but on school days when it is stinky, we have to play outside because there is not enough room inside for recess. I also play baseball for my school and want to play football next year. We have to practice outside, which can increase the risk for the toxins to get in us and harm me and my teammates. My siblings and I carry heavy water bottles to school each day. I would like to ask you what other testing has been done to make sure the drinking fountains at school are safe, so I don't have to bring my own water. I know that the water passes all the tests, but what about all the garbage soup that might be in it? My sister and I got to speak to the House Committee on Climate, Energy, and Environment to ask them to pass stricter methane monitoring requirements, and we were able to get that law passed. It's frustrating that we had to miss school to go ask for that, when Republic could just choose better technology to test for and fix their leaks. Those leaks could really harm the children and adults who live in and go to school in the area around the landfill. My sister and I want to be able to live in or near a Dare village and be in the fire department like our grandparents, great uncle, and dad have been. I hope this area stays safe enough for us to not have to move away. Please ask Republic to go back and clean up their room like I have to before you give them any more responsibilities. If they can't take care of their responsibilities now, why should they get more toys? I know I don't. Thank you for your time today. Please deny this application.
Thank you, Marcus.
Thank you.
Next, we have Greg Schiffer.
Thank you. Well, that's a tough act to follow. My name is Greg Schiffer, and I live at 2012 Northwest Arthur Place in Corvallis. Good evening, commissioners. Thank you for the opportunity to speak before you this evening. I have been a resident of North Corvallis for more than 4 years. I wanted to start by giving you a brief background on my credentials. I have a Bachelor of Science degree in Civil and Environmental Engineering from Penn State University, a Master of Science degree in Civil and Environmental Engineering from the University of California at Berkeley, a Master of City Planning degree in City and Regional Planning, also from UC Berkeley, and many years of dedicated public service in various government positions related to these fields of study. So I understand both the scientific and public policy considerations that you must take into account when making this critical decision. This may in fact be the most significant and important decision that you make as commissioners on behalf of your constituents and your community. And it will have long-lasting, serious, and likely irreversible impacts on the health, safety, and well-being of Benton County residents for generations to come. I am coming to you tonight in my personal capacity as a Benton County resident to ask you to please reject the proposed landfill expansion. My wife and I and many of our friends and family regularly use the Willamette River for recreation. We love to paddleboard and kayak on many different stretches of it. It is an essential public resource that must be protected. As we all know, we live in a very wet climate for nearly half of the year here. Much of that rainwater that falls on the landfill percolates through the trash and absorbs a wide range of pollutants, including PFAS, heavy metals, and other hazardous chemicals, creating a toxic soup that collects at the base of the landfill. I want you to think about how much more of that trash is electronic waste today compared to just 10 or 15 years ago. According to a 2021 EPA Science Matters newsletter published by their Office of Research and Development, which amazingly hasn't been removed from their website yet, quote, cell phones, televisions, laptops, tablets, watches, there is always something shinier, newer, faster, and smarter to choose from in the world of electronic devices. Americans currently own more than 3 billion electronic products. The average American has 24 devices per household. As the use of these electronic products has grown, the average lifespan of these products becomes shorter. This in turn has resulted in increased volume of discarded and obsolete electronic devices. The resulting waste, commonly known as e-waste, is the fastest growing component of the municipal waste stream in the United States, end quote. But most of that waste is recycled or otherwise diverted from landfills, right? No, in fact, the same EPA newsletter estimates that less than 30% of e-waste is recycled. The United Nations Institute for Training and Research reported last year that e-waste generation is rising 5 times faster than e-waste recycling, and the gap between e-waste generation and recycling is expected to continue to grow. To quote from the report, challenges contributing to the widening gap include technological progress, higher consumption, limited repair options, shorter product life cycles, society's growing electronification, design shortcomings, and inadequate e-waste management infrastructure, end quote. More electronic waste in municipal waste streams means more heavy metals and other toxic contaminants in landfills and in their leachate. The expansion of the Coffin Butte Landfill would generate millions of additional gallons of leachate each year contaminated with PFAS, heavy metals, and other hazardous pollutants that currently pass through the Corvallis and Salem wastewater treatment plants largely unfiltered and enter the Willamette River. Not to mention the unknown quantities of leachate that inevitably enter the groundwater and the river completely untreated. And I say inevitably because any reputable scientist will tell you that all landfill liners eventually leak. The EPA has acknowledged this as well. And monitoring systems only detect a fraction of these leaks. Therefore, I strongly believe that this landfill expansion would place an undue burden on this precious public facility, our prized Willamette River. With all due respect to the hard work that staff and their consultants have put into their report and recommendation, I believe that it is based on a fundamentally flawed assumption that the county has the technical expertise, capacity, financial resources, and willingness to meaningfully enforce the dozens of conditions that they are recommending be included in the approval. The history surrounding this landfill has clearly shown that this is not feasible, and a mere $80,000 annual contribution from the applicant for compliance monitoring and enforcement would not even come close to remedying the situation. With the ongoing severe and potentially permanent cutbacks to the federal government, especially within the EPA, the federal government's ability and willingness to effectively monitor the landfill's operations and emissions are now and will likely continue to be hampered for decades. That unfortunately puts more of the burden on state and local officials to do this work. As you all know, the track record for the state DEQ in this regard has been dubious at best. Despite what some testimony last night and questionable interpretations of the law may lead you to believe about the narrowness of your discretion in making this decision, you do have not only the discretion, but also the right and the duty to deny this proposed expansion to protect your community from harm. Denying this application to expand the landfill will not close the landfill anytime soon. The county and its citizens still have plenty of time to develop and implement much better and more sustainable alternatives to our waste management needs. Building a huge landfill in such a wet climate was a bad idea from the start. Please don't make another huge mistake by expanding it. Your primary responsibility as commissioners is to represent the interests of Benton County residents. Benton County residents do not need this landfill expansion, and Benton County residents clearly do not want this landfill expansion. Please do the right thing. Uphold the carefully considered and unanimous decision by your planning commission and vote to deny this application. Thank you for your time.
Thank you. Next up, Nancy Whitcomb.
I think I'm too short for this.
You can, if you need to like kind of bend it down, you can.
Yeah, there you go. Not a microphone expert. I'm a land use planner. My name is Nancy Whitcomb. My address is 37049 Moss Rock Drive. I am an architect with real estate development and land use experience. and I believe I am qualified to offer expert testimony on the subjects of real estate development and land use. Others have mentioned that the conditions of approval that staff recommends do provide monitoring of the conditions of approval. They have also said that monitoring is not enforcement. That was something that the Planning Commission focused on in their many hours of discussions about this. It sounds like it was about 500 years ago. The applicant suggests enforcement mechanisms, two enforcement mechanisms. The first is revoking the use permit, and the second is litigation. Neither of these is reasonable, responsive, or reliable, and neither of them would be speedy. And either would be a burden on the county that is unmitigated by conditions of approval, unless the county is just dying to get into the leachate hauling business, which I doubt that they are. Because 110,000 gallons of leachate per day are generated at the landfill. And if you revoke the use permit, who's going to be hauling that away? What I mostly want to talk about this evening is housing. Let's start by talking about one house, the Phillips property on tax lot 1103. The Phillipses are an older couple whose home is located at the back and at the top of their long lot. If this application is not denied, the forest a few hundred feet away from the back of their home will be chopped down. A hole will be blasted out of the mountainside in their backyard, and that hole will be filled with garbage that will eventually tower hundreds of feet above their home. The applicant knows that this application is incompatible with the Phillipses' continued occupation of their home. How do we know they know? It's in writing. In 2003, the applicant's consultant wrote that several parcels near the landfill were land uses not compatible with landfill operations, and called out the Phillips property specifically as one they were angling to buy. So the applicant knows that moving the literal landfill into the Phillips property's literal backyard will be a significant adverse impact on this older couple. If this application is not denied, the Phillips property will be rendered uninhabitable. It's in writing. It's on file at DEQ. Okay, let's move on from one house to housing in general, my area of expertise. I've designed and worked with developers to build literally thousands of units of affordable housing and market rate housing, mixed use housing, and so on and so on. If submissions open up again, I will have submitted under separate cover a paper by Richard Reedy of Penn State University. It is called, "Do Landfills Always Depress Nearby Property Values?" And his conclusion is that they do. A conclusion corroborated in Benton County by anecdotal evidence by local realtors. Mr. Reedy's paper concludes that landfills exert a chilling effect on housing within a 3-mile radius of landfill operations. That's almost an 18,000 acre area and encompasses all of Adair Village. Professor Reedy's research is pertinent because housing developers will not invest in the costly work of subdividing parcels and erecting homes on undeveloped parcels adjacent to the landfill if those homes are hard to sell. Developers need to maximize their profit because developing real estate is a risky business that usually entails borrowed money. If a newly built house adjacent to a landfill sells for 85% of a new house built elsewhere, the location near the landfill will never be developed. A landfill is incompatible with new housing on adjacent parcels zoned for housing. Adjacent to the proposed new landfill, there are many parcels that are already zoned for residential use. These include tax lots 1600, 0402, and 0400. Together, these lots contain 170 acres, all zoned for rural residential development, but currently not subdivided or developed for housing. If this expansion is granted, it is my opinion that it is unlikely that any home will ever be built on these 170 acres currently zoned for housing. On page 25 of the January 15th, 2025 application submission, the applicant acknowledges that seriously interfere is less than rendering the uses on adjacent property impossible. Your citation to deny is crystal clear. It's BCC 53-2151. The applicant's proposal rises beyond the standard of serious interference by making housing impossible on those properties. The adjacent lots, again, are 1600, 0402, and 0400. If this application is not denied, in my professional opinion, development of them becomes impossible. And the Phillips property, of course, would be devastated. If this proposal is approved, in my professional opinion, the parcels listed will never be developed to add to Benton County housing stock. They will remain forever underutilized or unutilized. This is serious interference, which is not new evidence, has been brought up in written testimony on numerous occasions. It has been brought up in oral testimony twice. It has not been rebutted by the applicant. It is not addressed in the staff report, and it is not mitigated, nor is mitigation attempted as a condition of approval. I listened to what all of you said was important to Benton County when you ran for office. What all of you said was that Benton County needs housing. This is an opportunity to add housing in Benton County. It is also an unassailable justification for denial, specifically that approval will make housing uses on adjacent property that are zoned for housing impossible. In this case, parcels that by any definition of the word adjacent and are zoned for rural housing will not be developable unless this proposal is denied. You can have a landfill or you can have housing. You don't get both. Would you like a copy of this?
You can, if you would like to submit it, you can take it out to the table that's out there.
I really don't care, but I'll give it to you if you want.
It just depends if you want us to read it or not. You can submit it out there. And next, the next three people that we have up are Jean Winessi, I'm probably pronouncing that wrong, Kenneth Postega, and Kevin Kanaga. Jean? And please correct my pronunciation for the record.
Good evening. My name is Jean Wisensee. I live at 1549 Southwest Birdie Drive, Corvallis. I moved to Corvallis in 1976 and raised my 5 children there. I am an RN and I worked at the hospital, retiring from there, and I continue to volunteer as an RN at our free medical clinic at Community Outreach. I volunteer because I care deeply about the health of our community, and I have seen what environmental decisions do to people over time. I vote in each and every election, and I voted for you. I voted for you because I believe that you would serve and protect Benton County. That's what you were elected to do. If you approve the expansion, Republic will bring in more outside garbage for profit while we bear the risk, the odor, the traffic, and the long-term harm. They do not live here. We do. Your own planning commission approved this. Your own planning commission rejected this expansion twice, not because it was anything else, but they felt that it was not in Benton County's best interests. The facts have not changed. You must now decide whether to side with the public that you were voted in to protect, or with a corporation that does not live here, does not vote here, and will not suffer the consequences of the expanded landfill. Please reject this expansion. Do not trade the health and the future of Benton County for Republic's profit. History will remember what you do here. Thank you.
Thank you. Ken?
Gabe and Pat, appreciate you taking all the time. My name is Ken Pastega. I live at 5480 Northwest Crescent Valley, Corvallis. I've lived in Corvallis since I was 14. I'm 79. So I've lived here for 65 years, and this is an amazing community. I'm firmly against the proposed expansion of the Coffin Butte Landfill. What's happening at Coffin Butte is nothing short of a train wreck. You look at East Palestine, Ohio, it happened one day. This has been going on for over 50 years. And one of the things that really bothers me is the due diligence of your staff. I think what should be done is to figure out what this meeting should be all about, what we're going to do in the next 14 years to fix the problem and what it's going to cost. Those numbers are huge and they should be evaluated as part of this discussion. I'm concerned about the amount of garbage the county has to take, and it's not fair that we have to have that responsibility. Our family proudly contributes millions to this community to provide local health care, education, children's programs, investments made to strengthen the community's long-term future. It is painful to see that same future threatened by short-term thinking that prioritizes convenience over sustainability. Expansion will harm the public health, the environment, and the reputation of the very place we call home. This is not progress, it's postponement. The county commissioners should not be debating expansion, but rather developing that 14-year transition.
Thank you.
was
Your
quick.
time is up. If you'd like to, you can submit that to the
Okay,
record at the table
okay.
up there.
Thank
Thank
you.
you. Kevin?
Good evening, Chair Weiss, Commissioner Lone, Commissioner Shepherd. My name is Kevin Kanega. I was one of the oldest graduates of PSU's class of 2015 with a science degree in environmental studies. My address is 37461 Soap Creek Road. Republic Services hired consultants, submitted an odor study based on 2005 on-site weather conditions, stating that they used the information because it was the only information available. I wouldn't have graduated if I submitted a research paper that based my findings on 20-year-old data set. We are all aware of climate change and how it has directly affected our weather patterns. Use of a 20-year-old data set just because they claim it's the only data available is not scientifically acceptable. At this time, it's up to you, our elected Board of Commissioners, to reject this odor study. It's hard for me to understand how this report was accepted by Benton County's hired consultants. Yes, the ones that completed the staff report using the flawed odor study as a basis for their recommendations for approval with conditions. Republic Services consultants' odor study lacks any scientific credibility and therefore serves as a denial of this application expansion. I've submitted a couple of charts that document the change in weather over the last 20 years. Another item. Staff notes from March 8th, 1983. Number 2, no landfill will be allowed on property south of Coffin Butte Road. Further down in the paragraph, the proposed zone allows no additional landfill activities unless approved by the Planning Commission at a public hearing. Therefore, you, the commission, may limit expansion into any area that is not appropriate for landfill. It is now up to you, our elected Board of Commissioners, to determine if the area in this application is appropriate for a landfill, thereby allowing you to deny this expansion application. Commissioners, I ask you to take a detailed look at Joe Crockett's testimony. It is there that you'll find these staff notes. Joe, thanks for your testimony. I think we can agree that there are 12 to 14 years of lifespan remaining, and that gives Benton County and Western Oregon plenty of time to find other solid waste disposal options. It's time to drive a change, not time to expand Coffin Butte Landfill. I also find it problematic with all the health concerns associated with the landfill. It's very disturbing that our Benton County Health Department has been allowed to decline from making any testimony. Thank you.
Thank you. The next three people are Laura Duncan, Faye Yoshihara, and Kevin Higgins. Welcome.
Good evening. Good evening. I am Laura Duncan. I live at 806 Southwest 5th Street in Corvallis. And I had to share that I am proud to be a great old brat for wilderness after hearing Maya and Pat last night. But tonight I'm here on behalf of Willamette Grange to oppose the expansion of the landfill. At our last meeting, we voted unanimously to submit a letter to you opposing this expansion. Willamette Grange has been in this community for over 150 years and supports environmentally sustainable practices so that the farmers in Benton County can continue to practice agriculture and support the community. In addition, it is our responsibility to be good stewards of this land. Commissioners, you are stewards of Benton County. It is your responsibility to maintain a healthy environment for all Benton County residents, as well as those downstream. The other points that I was going to speak about tonight have been shared by others, so I can cede the rest of my time. Thank you.
Thank you. Faye?
Good evening, Commissioners. Faye Yoshihara, 37461 Soap Creek Road. I oppose the expansion of Coffin Butte Landfill due to its impacts on the character of the area. I have many grave concerns, however, I highlight just one: odor. My October 3rd complaint demonstrates how the conditions of approval will not address the odor issues. Republic's environmental manager, Paul, got back to me and said their odor patrol did not detect any odors 1 hour before I smelled the stench. He even provided their data that showed that wind was not blowing in my direction, along with a diligent checklist showing nothing amiss with their operations. Check. Senior Air Quality Specialist Laura at DQ said she questioned Paul about the unusual chemical odor mixed in with multiple people reporting the same thing at the same time. But Paul could not provide any additional information other than to reiterate that they do not accept hazardous waste at Coffin Butte Landfill. Check. Paul did not respond to my follow-up question. From Laura, I gained an appreciation for how loopholes make it difficult for DEQ to enforce the state's nuisance odor law. One neighbor included wind direction evidence from her home, which Republic dismissed as inaccurate. Another, whose VOC monitor spiked, tried to report to DEQ, but the website was unavailable. Yet another knew she should report, but well, it gets exhausting. So boxes are checked. It is he said, she said, or he said, they, multiple neighbors said, all insufficient for action. Case closed, but please keep reporting. In a former life, I was a sensory scientist working with human panels to discriminate odor profiles for the purposes of claim substantiation. I'm glad Mr. Winterrow acknowledged smell blindness last night. He saves me from explaining the obvious. Republic's self-monitoring is unreliable. The staff report assumes COA P2-3 and OR4 with periodic H2S and nasal ranger monitoring and third-party verification will ensure compliance. They also imply we expect no detectable odor, which is ridiculous. I experience the vagaries of dump stench more than occasionally on my daily jogs in the valley, but I only report when it is nauseating and only at my house. Hydrogen sulfide causes paralysis of the olfactory nerve. Perhaps that is why they resort to blaming dead skunks, wastewater treatment plants, and PRC for our odor complaints. The EPA and the applicant's own consultants state that the public recognizes H2S at 2 to 3 parts per billion. We documented 250 to 500 parts per billion when dump odors rose to truly obnoxious nuisance levels 4 miles south of the dump. Meanwhile, the applicants use an assumed value of 36,000 parts per billion for their DEQ Title V permit. Are we expected to live with this when we may smell 3 parts per billion and are driven indoors by 250? Time, location, elevation are critical, but not addressed. The staff report dismisses the lived experiences of scores of neighbors when it places a high value on technical review, yet admits that weather systems produce different odor patterns. We've submitted images of trucks tipping their load, creating swirling dark clouds, drifting in multiple shifting directions over time. Really near neighbors know when a leachate truck is being filled. Nearby to far neighbors smell the smallest molecules, including H2S, which stay airborne for much, much longer. As the dump moves closer to homes, will more of us smell the stench inside with windows closed, as some have already reported? The applicant's lawyer described a process of adjudicating a noise pollution case in the last hearings. Twice through local processes, twice through LUPA, 7 years later, a revised COA. Is this the reality we face to get odor compliance? For 6 years of expanded capacity, the COA, even with county oversight, will not address the stench and seriously interferes with our daily lives. Thank you.
Thank you. Kevin?
Got to be able to read it. Good evening, Commissioners. My name is Kevin Higgins, 37615 Zeolite Hills Road, Corvallis. It's about 3.5 miles as a crow flies southwest of the dump. We moved to Soap Creek area just over 50 years ago, and we've called it home ever since. I realize this area doesn't fall into the classification of adjacent property, but the dump most definitely has affected the area as well as the character of the area. The second reason for mentioning my address is I'm not the only property owner of Benton. I'm not only a property owner of Benton County, but directly in the affected area of debate. This is contrast to supporters we heard last night. 5 or 33% of the 15 supporters live in the county. 0 live in the affected area, and 66% don't even live in the county at all. Yet they want to tell you how to vote. I'm a retired fire captain from Adair Fire. Was active for nearly 23 years and retired in 2022. I'm also the former emergency manager for Benton County, and I do still work for the county, but moved to become the special services manager for the sheriff's office. To be clear, I'm not here representing the sheriff's office. When I first started at Adair Fire, we were still having routine fires at the dump, some of them very large. Multiple alarms, many agencies required to fight those fires. One fire in particular was big enough to make the Associated Press as national news. That was in 1999. Some of those fires took all night to get out since the fire would be deep into the trash and would require us to bring a dozer in to move the trash around to get to the seat of the fire. These fires use a huge amount of water to fight. The landfill folks were always hated it when we started dumping thousands of gallons of water on the fire because it throws off their leachate. I know the fuel load in the landfill is huge, and that is why fire there requires so many resources. Fighting a fire there is one of the worst locations to fight a fire due to all the unknown fuel load and substances burning. It is so toxic that you basically have to fight the fire on air the whole time. You're wearing a CBA pack and on air for hours, but if you don't go on air, you usually cough and feel sick for days afterwards. Who knows what that has done to each of us that have fought those fires while not being on air. I often wondered what kind of toxins were released into the air, not only that we were breathing, but may have affected the environment also. My son Levi was also a firefighter for over 10 years at a dairy fire. Although he did not experience the 1999 fire, we both had similar physical effects of fighting a fire at the dump. Both experienced that our eyes would get sticky and goopy, and both would have burning in our lungs if we didn't stay on SCBA air. Our lungs would burn for days after, and we would feel lethargic and sick. The smoke was thick, black, heavy, and who knows the long-term effects of this. I imagine a scenario where we had a large wildland fire that included the dump. We would have toxic mess on our hands. A typical wildland crew wouldn't have the equipment to fight the fire at the dump, and the structure firefighters would prioritize working exposure protection of homes and buildings. That doesn't leave many resources to fight the fire at the dump and all the toxins pouring into the air. Granted, over the years, they've started doing something different because fire frequency started to slow a bit. The last few I went to before retiring generally started in equipment operating at the dump, but then would spread to the non-noxious trash. So we had an equipment fire and a trash fire to deal with at the same time. This often required mutual aid from Corvallis, Albany, or Polk County to assist. If approved, the Public Services says they will have 2 water trucks on site. 2 things about that. A water truck is not a fire truck. They're way different in capacities and capabilities. Also, if there is no people around that are trained on how to use those trucks properly, what good are they? Will they actually be able to handle a fire? If not, will they actually be able to handle a fire? In the early days of tarping to capture and contain the methane, I personally remembered fires that were under the tarps and feeling the methane explosions under my feet. Back then, I had to personally make large cuts in the tarps, which Republic Service hated when we cut our tarps. But we had to burp out that methane so it wouldn't explode underneath our crews. I heard representatives from the dumps at previous hearings say that never happened, but I can tell you it did. I was there. I did cut the tarps, and our crews did feel the explosions. It most definitely happened, and it was an eerie sensation to feel the explosion under your feet. Levi had also experienced the explosions under tarps and said it was terrifying watching and feeling the fire hitting so many hazardous materials and seeing the fire color change as it hits things like magnesium car parts, plastics, gas cylinders that weren't quite empty, petroleum products, and who knows what else. Landfill fires are not uncommon. A couple notable landfills that you should know about would be the Moody landfill fire in Alabama. Burned for over a year, is driven by illegally dumped construction waste. Lawsuits filed by nearby residents for medical issues and reported property value decrease. The Delta Shake and Shingle landfill fire in British Columbia in 1999, an underground fire in this landfill burned for more than 2 months. It cost $4 million Canadian to extinguish, and it was a state of emergency was declared. There's all sorts of impacts associated with these fires. Nationally, there's an increase in fires from lithium-ion batteries. EPA shows 64 Fires started at waste facilities alone over the last 7 years from lithium batteries. In closing, the Higgins family moved to Soap Creek Valley in the mid-70s. This is where I was raised and have memories of going to the dump as a kid looking for treasures. I was a young inventor, and dump looked like a lot different then. It was basically flat at road height, and just Benton County and maybe the surrounding areas dumped there. Now it's over 450 feet high, 22 counties and two states dumped there. My wife and I decided to move back to the Soap Creek area in the late 90s to raise our family. Our son, his wife want to move back to the area, and now they're expecting our first grandson. That would be 4 generations. And so for our family, the stakes are high. We want to protect and preserve the beauty of the health and Soap Creek Valley, the health and beauty of Soap Creek Valley and Benton County. Last 2 things, to be clear, I'm 100% in opposition of expansion of the dump. And second, I looked online, Benton County commitment to the environment, and this is what I found. It should help you with your decision-making process. Benton County, I quote, Benton County, Oregon demonstrates a strong commitment to environmental sustainability through various initiatives and plans. The county aims to reduce greenhouse gas emissions, protect natural resources, and promote sustainable practices in the area of waste management and land use. The dump is not, expansion clearly does not meet those commitments. Thank you for your time.
Thank you. And a little bit of good news, the next person is number 24 out of 46, meaning we're just over halfway, so it's all downhill from here. The next person is Michelle Emmons, followed by Greg Olson, followed by, I'm not sure if that's Miko, it's MKO, and then the last name is VIEUX. He declined. Yeah. So let's see, Michelle, I heard is not online, but is Michelle here in the room? I'll ask one more time for Michelle Emmons. Okay. Moving on to Greg Olson.
Okay, well, thank you folks for letting me speak up here on behalf of our county and our land. My name is Greg Olson. I live at 5394 Davidson Street in Albany. I am a retired registered nurse, and I changed my topic tonight to talk about odors in response to last night. The staff seemed to say that odors really didn't matter, that they were kind of irrelevant. Now, I think a lot of us have been affected by odors, but I just, as a registered nurse, I'm used to using a syringe. And that gives me an injection, or somebody else an injection of medications. Now, when we smell odors, it's not just a smell. Those are molecules of materials that have gone into our nose and have entered our bloodstreams. We have gotten an injection of landfill gases, an injection. A sniff is an injection. Smelling those things for a period of time is an infusion, like being hooked up to an IV machine of these chemicals. It just doesn't stay on the edge of your nose. It's into your bloodstream, and your brain is the one that is determining that this is a smell. Now, the primary smell, whoa, time goes. Primary smell is hydrogen sulfide, which is just a red flag because there's a bunch of others, the PFAS, hydrogen sulfide, the PFAS, methane, and a bunch of others. Just remember, odors
Real.
Thank you. Next up. I think it's you. And please correct my pronunciation for the record.
Mako View. I live at 954 Sycamore on the north side. I am a revolutionary. I'm the leader of an organization called the Pan-Indigenous Government, who's done over 300 direct actions, many to protect the environment. Got 34 million for Siletz River, etc. That particular one was the biosolids that were mentioned ended up over there, and the elk herds got deformed hooves, and the river was polluted. The wildlife, I agree with what was stated there. I eat the fish out of E.E. Wilson. There's a thing of class here where some people need the meat for sustenance. I also eat the camas. I'm a Potawatomi Dakota person, and I noticed that there's a lack of indigenous representation. Some of those indigenous governments can be coerced, but not ours, because we are with the people. The compost is a potential solution. It should be done by city and county. You need more community gardens. You need rooftop gardens normalized. The plan undermines the entire green belt and the Jackson Fraser. I am the youth foreman for the Jackson Fraser project, and I will be returning to see that through to the end. I see that there is corruption, and I notice when the lack of consent that was mentioned, because that's used against indigenous peoples. Water is life.
Thank you. The next three, Kristen Starkey, Robert Orton, and Catherine Bisco.
Wow, I didn't think I was going to make it up here.
We're trying our best. I think we're all doing great.
My name is Kirsten Starkey, and I live at 825 Goodnight Avenue here in Corvallis. And I thank you for the opportunity to testify before you today. I'm here as a representative of the Board of Directors for Bit by Bit Adaptive and Therapy Riding Stable, and we oppose the expansion. I have a degree in agricultural business management, a master's in business administration. I'm a licensed real estate broker and own a local brokerage. I urge you on behalf of our clients, volunteers, and the animals who make this program possible to reject LU-24-027. Bit by Bit is a small but powerful 501c3 nonprofit that provides adaptive and therapeutic horseback riding for children and adults with a wide range of disabilities and life challenges. We are also contracted through DHS Child Services to support foster youth through equine assisted programs. More recently, we proudly expanded to include equine assisted physical therapy to offer vital services that simply can't be replicated in a traditional setting. For many of our riders, these sessions represent the first time they've experienced confidence, independence, and connection. Our stable and property share 2 direct borders with Republic Services forest land and sit among the closest neighbors to the proposed expansion site. Because of our location, the program has already been deeply impacted by existing Coffin Butte operations. The proposed expansion site will bring dump operations dramatically closer to our program site and will more seriously interfere with the use of our property in violation of BCC 53.2151. Trash has become a constant presence in the pastures and paddocks, the same spaces our therapy horses rely on. While volunteers work tirelessly to clean the property, airborne plastic and paper are regularly deposited on our land, and bits of plastic remain embedded in the soil. I have been out there numerous times and I walked the pastures and picked up the trash, so I can attest to it being there. These fragments threaten the health of our animals and contaminate the land and water we all depend on. One small piece of plastic can prove fatal to a horse. Portions of our property are now unsafe for horse turn or exercise, rendering key parts of the facility unusable. The ongoing blasting operations pose another serious interference and danger. Horses are sensitive animals, and the sudden explosions terrify them and their riders. Imagine a child with special needs or a foster youth already working to build trust and emotional regulation, suddenly atop a startled horse. Even one expected blast can undo weeks of therapeutic progress, and yet we're often given little to no notice to prepare or reschedule. When we are actually notified of impending blasts, they are vague and cover unrealistically large blocks of time. The economic viability of our program is affected when we can't schedule appointments for large blocks of time. These safety and environmental issues are compounded by the odor and air pollution that regularly drift from the dump site. Clients and families have commented on the stench and noise, and some have even questioned whether it's safe to continue their sessions. This not only threatens our ability to serve the community, but jeopardizes the sustainability of the entire program and business operations. If this expansion moves forward and the dump operations move even closer, the already thin buffer between our property and Coffin Butte will vanish. The risks to our animals, clients, and staff will increase dramatically. It is difficult to see how bit by bit could safely continue to operate under these conditions. As a realtor, I can also attest that such an expansion would have a negative effect on the property values. Due to the proximity of the dump, relocation would be financially impossible for Bit by Bit, as there would be a stigma attached to their property. Specifically, the state of Oregon requires sellers to provide buyers a property disclosure statement. Adjacent dumps cause a material defect or a potential hazard to the property. Thus, the seller must disclose it by law. Oregon law requires sellers to disclose any material defects that are not readily apparent and could affect the property's value or desirability. I respectfully ask each of you, what would it take for you to live adjacent to a major regional waste disposal site? How much would the seller have to reduce the price on a property for you to take the gamble and live there? This very question would be asked of any potential buyers of the Bit by Bit property. And if we are being honest, it would require a substantial price reduction to make living there tenable. In fact, I suspect if many of those supporting the expansion had a home and or a nonprofit that shared a property line with the dump, they likely have had a different opinion. Being forced to accept a sizable market value reduction simply to relocate to somewhere safe would leave Bit by Bit without the financial resources to find a new home that could accommodate the horses, the stables, the paddocks, a round pen, tack room, hay storage, and equine properties consistently sell at a premium. The closer the dump gets to the property, the more negatively the market value will be affected because potential buyers are asked to accept the blast, the odor, and the airborne plastic and trash. This property's highest and best use has always been for livestock and agricultural uses that would become untenable under the shadow of a landfill expansion. Bit by Bit is more than a nonprofit. It is a lifeline for individuals who often feel unseen. To lose this space would be more than an inconvenience. It would be a profound loss to our community. I respectfully ask this commission to protect this valuable community resource by denying LU-24-027. The people and animals who rely on Bit by Bit deserve better than to be collateral damage in an expansion that serves no one at the local level. Thank you for your time and your compassion considering what's truly at stake. Thank you.
Thank you. Since you asked as a Benton County Commissioner on a second term salary, I can afford none of the houses that have recently been for sale next to the
I hear you.
landfill. So
I hear
if
you.
anyone does have a house, they won't, no, just kidding.
Yeah, I know.
Just kidding. I'm just kidding. I'm just kidding.
No.
Thank you
I
though.
hear
Point
you.
taken.
It's a challenging situation, but the current climate with the dump near Bit by Bit is making it.
Oh, Commissioner Shepherd has a
I
question.
actually have a question.
Okay.
Sorry, I missed at the beginning. Do you have the address of your nonprofit? Specifically the nonprofit or a tax lot or something like that? Well, I have the name, but
Oh,
the
yeah, I
the
think
name
it's-
doesn't help because we can't, with the record, we can't Google it.
I can find it and I can put it in the record with my statement. and
Okay,
add it
thank
to it. But I can just search by Bit online. They have a website.
I believe if you registered, we should have your address. It's just, we need to be able to set for part of the rules. We
Well,
send you a notice.
Not
Oh,
the testifier's
Yeah, no.
address, but the location of the nonprofit
Of
is
the
what I was.
stable Bit by
Yeah.
Bit. It is, yeah, it's as close as you can get. It's one property that is as close as you can get to the expansion
Okay,
site.
if you can put an address or a tax
I
lot.
will.
Okay, thank you.
I got it.
Thank you.
Good.
Ne-
Can I look at the address and give it to you?
That's a question for our council. Is it okay if they tell us the address right now?
Over there, I can grab it.
I assume this is relevant to.
The reason I'm asking is because the statement was that this is a nearby, the property is close by, but I would like, in the analysis, I want to know
How close it is? That's fair.
if it's within the, I'm looking over at our council here to help.
I think that'd be
guide.
valuable information. To know the address.
Okay.
38578 Oregon 99 West, Corvallis.
Thank you.
Thank you. Sorry, that was mine.
All right, next up, we have Robert Orton. Sir, if you could sit down and speak into the microphone and
Sorry.
please start with your address.
First, my address, 2435 Salem Avenue, Southeast Albany, Oregon, 97321, I believe. Boom. I'm a whistleblower from Coffin Butte Landfill. One thing we have not talked about during this is the source of the information and what you're getting. Veracity, integrity, mean everything. I'm going to read you a couple of emails from my time at Republic Services directed to local management. We were unionizing at the time because of the health issues. Number one, questions of great concern to myself and fellow employees. One, what has been done to address the methane leaks at Coffin Butte Landfill reported by the EPA? Two, is the air there safe to breathe? Three, are explosive levels of methane still escaping? Five, given that the company's own monitoring and reporting is demonstratively unreliable, can anything the company report be taken at face value, or is the information designed to be wholly self-serving? Six, are employees being kept safe? Seven, is the environment being protected? Ever humbly, Robert Orton. The response to local management came 2 days later. This is January 26, 2024. And this is from regional management. Mr. Orton, thank you for your email. Coffin Butte's gas collection system is robust, 3 times the industry standard. It is critical to controlling emissions as required by the EPA. Further, the landfill meets or exceeds the tightened requirements that were detailed in President Joe Biden's U.S. emissions reduction plan. We've made substantial investments in our gas collection and control system in recent years. This includes the installation of 57 new vertical wells and 22,700 feet of horizontal gas collection piping. One of those projects coincided with the 2022 EPA inspection you referenced in your email. We believe this work temporarily impacted the overall efficiency of our systems as we made gas systems adjustment, performed enhancements, and dug through waste disposal area. This led to an unprecedented negative impact on the readings. We have since taken corrective action as recommended by the EPA. Let me repeat that line. We have since taken corrective action as recommended by the EPA. The EPA recommended no corrective actions. That was verified by the EPA. Goes on, Coffin Butte did not receive any notification of violation as a result of the inspection. Republic Services is a sustainable company. Safe is one of our core values. The air in the landfill is safe to breathe, and we continue to work closely with our regulatory partners at the local, state, and federal level. We remain in compliance with all of our regulatory permits and requirements. Signed, Brett Davis, General Manager. Now, I sent another email because my questions weren't answered, and acting in my capacity as steward out there to Brett. Much of the same. What you have there is a lie, demonstrable beyond a doubt. You have regional management for the company lying to local employees. Prior to that, Ian McNabb, who was the environmental officer during the time of the EPA inspection, lied to the EPA, as the EPA pointed out. He was retained for employment by Republic Services, as is local management, who has lied and testified before you. That was the end of January.
Thank you, sir. Catherine?
Good evening, Chair Weiss, Commissioner Shepherd, and Commissioner Malone. Thank you for this opportunity to speak before you this evening. My name is Catherine Bisco. I am coming before you this evening as a member of our community. Let me get to my notes here to get started. My address is 510 North 13th Street in Philomath. And I'll go ahead and get started. It was assured at the July 22, 2025 Planning Commission meeting that the Planning Commission record of all public testimony, all revisions of the application, all revisions to the staff report would be part of this record. This is not the case. I request at this time that staff do so as was presented to the Planning Commission. Submitted for the record tonight by myself as written testimony, is 87 pages for your consideration to Benton County at the front desk. I strongly encourage you to review the submitted opening statement that was part of the Planning Commission's deliberations on July 22, 2025. That's my opening statement, and the 40 documented reasons for denial and corresponding email to Benton County expressing irregular procedural concerns of the land use process of LU-24-027 to the Planning Commission. My testimony tonight is only presenting the first of these 87 pages. Excuse me while my document cooperates. You'll have to forgive me, my document. There we go, just went missing. I am a resident of Benton County for almost 22 years. I'm a former city of Philomath City Council, member of the Benton County Planning Commission currently since January of 2023. The only planning commissioner that also served for the 8 months of the Benton County Talks Trash 2022 to 2023, and a member of one of the 5 subcommittees, the past land use application conditions of approval subcommittee. I served on Oregon's Department of Land Conservation and Development Local Officials Advisory Committee, and I have had 10 years of local government land use experience in Philomath, Corvallis, and Benton County. Also a graduate of the 2021 Land Use Leadership Initiative by 1,000 Friends of Oregon. In the process of Benton County Talks Trash, I had the opportunity to tour twice the Coffin Butte Landfill, once during BCTT in the fall of 2022, a second time with the Governor's Regional Solutions Team in September of 2023, and the neighborhood tour sponsored by Benton County Talks Trash fall of 2022. I am one of 7 planning commissioners that unanimously denied this landfill expansion application in 2025 after review of the estimated more than 7,000 pages of record and approximately 20 hours of public testimony. I am providing this testimony as an individual and not representing members of the full body of the Benton County Planning Commission or BCTT work group. I do support the testimony of the opponents as presented yesterday and this evening, each bringing their own expertise and research to this commission. I am going to skip around just in the interest of time and because of the magnitude of what I have provided to you in written testimony. My goal is to provide you from a decision maker perspective, some things that I found important in the record and through the process. And I'll just start here. So bear with me with the continuity. Know that the rest is probably sitting in that document provided for the record. A Tale of Two Landfills is how I saw this whole experience. And it's an excerpt from my opening statement on July 22, 2025. The Planning Commission and the public are hearing 2 disparate landfill stories. First, the assertions and records from Republic Services, the applicant, and then very differently from the public testimony, eyewitness accounts, and personal experiences and observations. Much of this testimony was very compelling. The question to be considered is whether Republic Services application for landfill expansion has met the burden of proof using code criteria, in particular BCC 53.215 regarding seriously interfere, character of the surrounding area, and the imposing of undue burden on county services. This is the focus of my opening statement. The applicant has portrayed an operation that is fully in compliance with regulatory agency and one that is operating as a good neighbor and with regard to Benton County residents. Public testimony from hundreds of Benton County residents, member organizations representing hundreds more, environmental groups, visitors to Benton County, neighbors of the landfill areas outside of Benton County, and observers have noted that compliance with past conditions of approval, regulatory oversight, and safety protocols may not be occurring. Procedural concerns that I had in this process, the findings of the Planning Commission were abbreviated and as such do not outline the full reasons for denial. The full record of the Planning Commission deliberations can only be heard in the recording of the July 22, 2025 meeting. The process was poorly administered in preparation, providing the Planning Commission provisions to the Planning Commission, and during the meeting with what was perceived as heavy-handed steering of the deliberation and ultimately an omission of many critical findings necessary to document justified reasons for denial. The planning commissioners were not prepared with directions on what would be required in that meeting to support the findings of fact for the final record. When planning commission members responded to surprise requests by staff and legal counsel for specific language for findings, best efforts were made by Commissioner Lee, Wilson, Struthers, Fowler, Fulford, and myself. However, it was another surprise when the staff drafted record of findings as presented for final adoption by the planning commission that many of the key reasons for the denial were omitted, leaving the Board of Commissioners leaving for the record and for the Board of Commissioners an incomplete record of findings for denial. No options for revision were accommodated by design at the July 29, 2025 meeting. Why does this record matter? Well, for this appeal process, of course, but for the history of the landfill land use record as well. It is noteworthy that many of the past land use conditions of approvals are no longer considered applicable by county legal counsel due to procedural regularities such as these. These conditions of approval compliance have not been adjudicated. For this record, I provided a document in appendices of my testimony of the 40 reasons for denial believed to comply with criteria outlining the extensive gaps in this application as presented to the Planning Commission. You are being presented a similar application in this hearing process. These gaps remain in the newly revised application. It is noted that the Planning Commission was responsible for noted that in 2022, the Planning Commission was responsible for drafting the final findings of the record for the 2021 denial of the landfill expansion. It is unclear why staff and legal counsel were given this important task for the Planning Commission hearing rather than the Planning Commission body itself. Much has been made about definitions in this new application and before this body, as well as with legal counsel. With that in mind and knowing the importance of seriously interfere, I did some looking to present for you this evening. So serious in the root word by Merriam-Webster, Common Language 11th edition, was having an important or dangerous possible consequences, a matter of importance, excessive or impressive in quality, quantity, extent, or degree, seriously, in a sincere manner, or earnestly, to a serious extent, severely, or extremely. Interfere by Merriam-Webster was to interpose in a way that hinders or impedes, to enter into or take a part in the concern of others, to act reciprocally so as to augment, diminish, or otherwise affect one another. So I asked this Board of Commissioners, fellow decision makers, would the loss of springs or wells on a person's property adjacent to the landfill be serious interference? The answer would be yes. Would the loss of carefully selected breeding or show animals for a livestock program be serious interference? I believe it would be yes. Would effluent from millions of gallons of untreated leachate dumped into the Willamette River be serious interference to downstream drinking water and recreational users be serious interference? Yes. Would confinement to one's home to avoid offensive odors outdoors on one's property be serious interference? Yes. Would inability to hire farm workers to manage organic field crops or vineyards be serious interference? Yes. Would health impacts from known cancer and other disease-causing emissions or pollutants be serious interference? Yes. Would bioaccumulation of airborne toxins, heavy metals, bisphenols, phthalates, PFAS, and cancer-causing substances known to be dispersed through methane and other gas emissions, dust, and wind be serious interference? Yes. Would any uncontrolled fire scenario that impacts regional resources, threatening homes and businesses, harming local wildlife refuges be serious interference? Yes. Would road hazards from trash, litter, and debris on Route 99W and other supporting roads be serious interference? Yes. Regarding cumulative effects of significant impact, such as in Yamhill County versus Stop the Dump, a discussion of definition related to serious interference, which was had at the Planning Commission meeting of July 22, 2025. In this case, the Oregon Supreme Court determined that the code criteria had not been applied with consideration to the quote cumulative effect, end quote, of the impacts of the landfill expansion. The staff report for this application and applicant's presentation presents no such evaluation, instead choosing to minimize impacts by isolation, alleging odor can be addressed, that noise can be addressed, that traffic impacts can be addressed, etc., all in isolation, many through extensive conditions of approval and monitoring. Here, as in Yamhill County versus Stop the Dump, the analysis of cumulative effect of adverse impacts was not taken into consideration and should be as it relates to Benton County criteria, serious interference in particular. Would cumulative effects of odor, noise, pollution, contaminants, toxic bioaccumulations, traffic impacts and hazards, well water risks be serious interference? Yamhill County versus Stop the Dump says yes. Expert. Much has been said about the term experts as guided by legal counsel before the Planning Commission in the staff findings drafted for adoption and in the Republic Services PR campaign, Benton Clean and Strong, and the current de novo application before the Board of Commissioners. Expert, according to Webster, is having, involving, or displaying special skills or knowledge derived from training or experience, or experienced. As a member of the Planning Commission, I found that the expert consultants provided by the applicant were often unable to answer numerous basic questions of clarification posed by the Planning Commission. This gap in skills and knowledge is repeated on subjects of traffic, odor, modeling and reporting, wildlife impacts, groundwater impacts, methane and fugitive gas emissions, bioaccumulations of toxins, heavy metals, PFAS, leachate contaminations, fire management and fire risk mitigation, and impacts to wildlife, refuge and preserve areas. As a planning commissioner, I expected the experts to be able to answer the difference between hazardous and special waste, to respond intelligently about contaminated waste coming to the landfill, to circumstances that may require the landfill to take hazardous waste, to the risks of medical waste used as alternate daily cover, and the assurances that waste was checked for contaminated or illicit materials. Surely the discovery of human remains of 2 women, one in 2022 and one in 2023, shows gaps in this load checking process. I expected the landfill to provide evidence of compliance with DEQ and EPA compliance on federal and state requirements, expected Coffin Butte Landfill to comply with OSHA regulations on safety and training to protect their employees. The record reflected considerable gaps in these assurances. To that point, Coffin Butte Landfill has been cited by DEQ, EPA, and OSHA in recent years for violations. Additional investigations are incompleted. Adjacent. In recent Benton County land use decisions, its own precedent and recent history. County precedent in evaluating adjacent can be seen in recent land use decisions in 2023 and 2025 before this planning commission, reflecting far greater historical and current interpretations of the word adjacent. The county code does not provide authority for an applicant to predetermine the terms adjacent in any land use hearing before the planning commission. And since 2023, has that been cited, nor has it allowed the staff to predefine seriously interfere, undue burden, or character of the area. The definition of adjacent includes nearby counties, acreage, cities, special districts, neighborhoods. In the Webster's dictionary, it cites the city and adjacent suburbs, suggesting that adjacent is not simply a matter of shared property lines. It does refer to in close proximity. How do we define close? Areas that are subject to impact, not necessarily limited to adjoined or contiguous, is also cited in Webster. Keeping perspective, the definition of adjacent as it relates to the impact as established in criteria Benton County Code 53.215 is prudent and relevant. Without the landfill site at this location, the neighborhoods, farmlands, vineyards, small businesses, communities would not be experiencing the same impact that is clearly evidenced in this record and would increase with an expansion. I've included in my packet of materials a citation of examples of ambiguous and inconsistent interpretations of the word adjacent in recent Benton County land use decisions. Land use 25-022 was an application to reestablish and improve an historic campground located on a 150-acre parcel zoned forest conservation, proposed to be operated as a public campground. Adjacent property impacts included to the LC Falls Recreation Site included coverage of 3,244 acres of wilderness. The staff report and planning commission hearing process did not limit or interpret the definition of impacts in this case. However, risks of wildfire were considerable parts of deliberations. Also considered adjacent were properties owned by Bureau of Land Management, Tall Corn Forestry, Weyerhaeuser Timber Holdings, and Nystrom Land and Timber, totaling hundreds, if not thousands, of acres of adjacent properties cited in the staff report. I've included a map of the LC Falls recreation site that was part of that application in it was August 19, 2025. During the hearing for this application, staff in discussing impact to adjacent owners referred to the approximately 1 mile trail that links LC Falls to Grant Peak Falls. Extensive deliberations by the Planning Commission was allowed to be had on fire response times, fire protection service, road accessibility to fire equipment, present where the fire chief of Philomath Fire District to provide testimony and respond to questions. This was not the same case for the Coffin Butte Landfill expansion application. In 2023, the adoption of an evacuation route through an OSU sheep pasture was brought before the Planning Commission. In this Benton County land use case, impacts of the application were considered far exceeding the impacts of the Coffin Butte landfill as proposed by the applicant. The impact area for this application was from west of Corvallis to Wren, North Philomath, and Highway 99W near Sulphur Springs Road, a distance as the crow flies by as much as 6 miles. The site map and Exhibit A from this application is included in the packet for your reference. I'd also like to note that the Planning Commission took note of the presentations before the commission by interested parties, both in written and in person. Opposing voices from the organizations actually represented more than 100,000 individuals in membership, including many experts. And for reference, Benton County's current population is cited in 2024 as 98,900. So 100,000 individuals represented in opposition is significant. Of these groups include the Benton County Democrats, the Benton County Republicans, Benton County Pacific Green Party, the League of Women Voters, Corvallis, Oregon chapter of the Sierra Club, 350 Salem, Great Old Broads of the Wilderness, Valley Neighborhood for Environmental Quality and Safety, Mid-Willamette Bird Alliance, the Audubon Society of Corvallis, Volunteers of Willamette River Keepers, NREC, the Environmental Natural Resources Advisory Committee for Benton County. Beyond Toxics, the Adair Rural Fire and Rescue. Elected officials, submitting as private residents, Willamette River Keepers, Lucky Meat Watershed Council, Willamette Grange, Marys River Grange, 1,000 Friends of Oregon, the Benton County Soil and Water Conservation District, and others. The expertise and impact of the testimonies in the record from these groups was a powerful representation of the community and organizations associated with relevant public interest stated in Benton County Comp Plan and the evidence of serious interference, undue burden, and character of the area. The credibility of this public testimony was noted for its relevance by the Planning Commission as founded in the hearing record, while challenged by Benton County Legal Counsel on the final findings draft and in the instructions to effectively disregard public testimony that was not adjudicated, a troubling direction that caused Planning Commissioner Cash to ask for clarification deep into the hearing process of what testimony could be considered. The Planning Commission heard testimony in opposition from highly educated and credentialed experts from within the community, accounting for lifetimes of work in their fields, having shed light on this application for landfill expansion. Scientists, educators, contractors, consultants, farmers, environmentalists, mechanical engineers, hydrogeologists, civil engineers, land use planners and architects, GIS analysts, spatial data experts, toxicologists, wildlife biologists, former EPA employees, cancer researchers, fire chiefs, farmers, vineyards and winery owners, recreational birders, teachers and educators, professors of fish and wildlife sciences, peer-reviewed journal articles, credible news articles, EPA and DEQ findings, BCTT findings, Solid Waste Advisory Council, Disposal Site Advisory Committee members, Environmental Natural Resources Advisory Committee, and more. Again, planning commissioners consider these as relevant and expert testimonies. Also of note was that state and federal elected officials had taken notice. You've heard the testimony of our representative and senator, but also cited in my reports was those involved previous to this testimony in opposition included Senator Sarah Gelser-Bluin, Senator Deb Patterson, Representative Sarah Finger McDonald, U.S. Senator Ron Wyden, U.S. Senator Jeff Merkley, and U.S. Representative Val Hoyle, and many others, each recognizing the risk and unsuitability of this landfill and any future expansion at its current location. It is now clear that this landfill and its proposed expansion does not just affect nearby properties and residents of Benton County. Testimony shows its impact in surrounding municipal and rural Benton County, nearby Polk County, farm and agricultural lands. Methane and fugitive gas emissions during the hearing were documented along with particulate matter with these emissions and a blowing daily cover that brings a risk of bioaccumulation of heavy metals, etc. The risks in this area, Benton County, families, farms, vineyards, and economies is relevant. In this week's news, Pacific Corps settled a negligent suit related to the smoke and soot bioaccumulation on vineyards. It's not hard to imagine bioaccumulation impacts to our region. We cannot consider the Benton County Talks Trash COP subcommittee and the architect of the phrase must consider, and the architect of the phrase community expectations, Ed Patera, who is no longer with us as he passed away since his work on Benton County Talks Trash, but whose work is significant to the findings and recommendations in the BCTT final report. Ed leaned into the social contract between county and its residents, and more specifically, what the community expectations have been as documented in the 50 years of landfill land use applications in Benton County. These expectations have not been met when considering the oversight and management of conditions of approval for the landfill. The comprehensive plan in the Benton County Code and its intersections apply to this landfill expansion. The 2040 Thriving Communities Initiative also apply to this expansion, including all of the core values 1 through 10. Oregon statewide land use planning goals apply to this land use expansion, both directly and indirectly through our comprehensive plan. My reasons for denial, again, are outlined in my submittals, but several of those rise to the top of the 40 reasons. Some of these are the application for landfill expansions, inconsistency with Benton County Code regarding seriously interfere, undue burden and character of the area, the undue burden of the county of hosting and expanding landfill, the adverse impacts to and the use of surrounding natural areas, the risk of the construction of the expansion area, specifically basalt ridge blasting and unpredictable fractures that may have adverse impacts to regional water, the bioaccumulations of toxins and heavy metals, etc. The failure to address noncompliance and lack of safeguards regarding state and federal regulations, the lack of management and adequate oversight or load checking to prevent uncontrolled, contaminated, illegal, and hazardous waste from entering the landfill. The application failed to sufficiently meet the burden of proof as to how Republic Services will mitigate undue burdens, serious interference, and impacts to the character of the area, as well as other regulatory and safety compliance, including handling of hazardous waste, leaving with the Planning Commission with insufficient application evidence to approve the expansion. What was also found to be insufficient or missing from her public services application was adequate controls, mitigations, or improvements to address persistent odor issues, not just reporting. Adequate evidence of ability to manage uncontrolled methane and other biogas emissions, adequate measures to address leachate impacting local surface and groundwater, an industry known fact, adequate evidence in application of natural resource area protections for E.E. Wilson, impact analysis of traffic did not address construction traffic, evidence of adequate checking of waste loads coming into landfill for toxic materials, hazardous waste, adequate measures to address particulate matter contamination, ability to address the safety risks inherent with medical waste, sufficient planning and measures to respond to fire risks and uncontrolled fire scenarios, reclamation, conditions of approval, and cell closures. Questions could not be sufficiently answered by the applicant and is a completely relevant issue for this expansion. Missing from landfill expansion application evaluation of cancer clusters and what are known as dump deer in other parts of the country related to landfills. Missing in traffic impact analysis were accident rates, nearby road impacts, county data cited traffic types, road hazards, rock chips, potholes, broken windshields, and broken windshields. No assurance of cost enclosure and post-closure, as there are large loopholes allowing for default. This is an essential component of hosting a landfill that will impact Benton County long after public services. I urge you commissioners to deny this expansion for application. There are further considerations for you to consider in the 87 pages that I submitted for the record this evening. Thank you.
Thank you. Okay, so we were scheduled tonight to go to 10 o'clock. It is 10:10. However, I think we can push through some more. We have over an hour of people signed up left. I'm not sure we can get to everybody, but we're gonna keep going. Next up, Robert Bisco, and then Susan Walenza and Bruce Frey, MD, PhD.
Hello, my name is Robert Bisco, P.O. Box 848, Philomath, Oregon. Commissioners Shepherd, Malone, and Chair Weiss, thank you for giving us the opportunity to speak tonight. I appreciate your thorough and thoughtful attention to doing your best to fulfill your duty as a commissioner to protect the health, safety, and well-being of Benton County residents that voted for you in your office. I'm opposed to LU-24-027 for the expansion of Coffin Butte Landfill, and I implore you to uphold the Benton County Planning Commission's unanimous decision to deny this application. There's an amazing amount of evidence to uphold the decision due to the undue burden, serious interfere, and the application does not fulfill burden of proof. Please review day 8 of the YouTube video of the Republic Service conditional use application regarding Coffin Butte landfill expansion from 7/22, starting at 2 hours and 26 minutes. That will go into the details of how many different reasons for denying the application and some of the things that Catherine mentioned earlier. I requested that you continue this hearing to allow the rest of the residents that have signed up to testify before you. I believe it's the least that can do to allow them to speak one of the biggest decisions in Benton County's history. I will cut my time short just to say that I agree with the following testimonies of Robert Kipper, Virginia Scott, Peg Herring, Jeff Kleiman, Joel Gear, Mark Yeager, Kinko Denzer, Mason Levitt, Pam Castle, Debbie Palmer, Ken Eklund, Ken Kanega, Mark Henkels, Nancy Wincombe, Kevin Higgins, Catherine Bisco, and hopefully we're gonna get to Dr. Shelley Sue. So thank you so much for your time. And I am excited to for Benton County to turn to a new chapter to explore the potential of a public-private partnership like Lane County is doing right now to reduce the waste. Thank you.
Thank you. Susan?
Thank you, commissioners. I speak, I'm Susan Walenza, 1415 Northwest Greenwood Place, Corvallis. I speak simply as a grandmother. Clean air, water, and soil are precious, irreplaceable resources. We must not expand the degrading of our forever environment here in Benton County. There's a strong link between wet conditions and landfill leachate creation, well known to be a main source of PFAS, forever chemicals. According to the EPA's our current understanding of the human health and environmental risk of PFAS, exposures can be high when people are exposed to a concentrated source like a landfill over long periods of time by swallowing contaminated soil or dust or breathing air containing PFAS. Some PFAS accumulate in the body over time. And because children are still developing, they're more sensitive to the harmful effects. Once PFAS enter the environment, it's difficult to remove them as they include a large number of individual compounds with low concentrations. Key is not to disperse them. This happens when abundant leachate is created at Coffin Butte and then escapes via landfill gases or is disposed of in the Willamette River. The issue is the irreversibility of contamination in the environment and effects on brain development of children, endocrine disrupting effects, carcinogenicity, toxicity to reproduction, effects on immune system, and lipid metabolism for a broad range of PFAS. Please safeguard us, your constituents, and our environment and oppose this expansion. Thank you.
Thank you. Is Dr. Bruce Frey here? I'll call one more time for Bruce Frey. Okay, moving on. We will go to the next three. Hazel Sievers, Steve Michaels, and Keith Lemke. Thank you for staying late with us tonight.
Hello, my name is Hazel Sievers. I am a resident of Corvallis and I live at 1660 Southwest Martin Street. Thank you also for being here late tonight. I am a senior at Corvallis High School and I am the president of the Green Club and the High School Democrats Club. And I should add that I am not representing this party as a whole, just the members of the group at CHS, which is about 15 students in that club and about, I would say 30 in the Green Club, depending on the day. I am here testifying today on the behalf of these student-led organizations. And I'm urging you to please uphold the Planning Commission's unanimous decision to deny the passage of LU-24-027, which would, of course, expand the landfill. So as a member of the rising generation of land stewards and fellow community members here in Benton County, I feel that it is my responsibility to express our deep concern about how this expansion is specifically not addressing waste reduction, as well as its impacts on public health and the environment. After my research, here are a few of the concerns that really stood out to me. As others have said, the leachate from Coffin Butte is filled with PFAs that stay in the water even after being treated and have been deemed hazardous by both the DEQ and the EPA. Also, the leachate that is diverted and dumped into the Willamette from the wastewater treatment plant is the water that people in our community are drinking. While most of this leachate is diverted, some still percolates into the soil, and due to insufficient liners and heavy rainfall in the Willamette Valley, enters our soil. So this risk will only be increased by the expansion. These and other factors such as methane leaks and litter, again, as expressed earlier, are going to be exacerbated by the expansion of the landfill. But please don't take my word for it. You've heard from many qualified professionals. Another disturbing factor that seems to be driving this application is Republic Services' monetary interest in overturning this decision. Coffin Butte is Republic Services' last stronghold in the Pacific Northwest and a large source of revenue. Because of this, increased waste is only a benefit to the company and does not consider waste reduction or education measures. Instead, it incentivizes the increase of waste. This worries me. While I understand that a landfill expansion may seem necessary to accommodate future waste, it will not fix the underlying problem of increased waste altogether, something that I believe we must be addressing in any decision involving waste processing today. It is unreasonable to assume that people will automatically reduce their waste, but by endorsing this landfill expansion, we are sending Republic Services and our community a clear message that we agree with their motives that do not include potential waste reduction solutions. If we deny this request, however, we can direct resources toward creating a plan to perhaps go zero waste in the future, using models such as the one created in Kings County, Washington. We could implement composting in local schools, something that still does not exist today, or establish sustainable recycling solutions such as those formerly used at Cardam Recycling Center in Nehalem, Oregon. These will not produce harmful toxins into the environment, but could still be part of the Republic Services goal. So in the long run, we could solve the waste problem rather than exacerbate it. Coffin Butte still has some years of life left, so stopping the expansion will not end the landfill's resources immediately. This means there will still be jobs and places to put trash that might otherwise be dumped on private property, as these were all concerns that I heard addressed last night. These are just a few of the many reasons that the landfill expansion should be denied. We, my peers and I, refuse to cooperate with the requests of people and corporations who continue to jeopardize our ability to grow up in a society that values waste reduction and the environment and the well-being of our neighbors. We do not believe the growth of a large profit-driven and environmentally degrading organization should be prioritized over our people and our planet. If we, the children and the young adults of today, are to continue living in a healthy and thriving Willamette Valley that provides us with healthy food, clean water, and uncontaminated environments for wildlife, we must find a different solution because we will not be able to keep expanding our waste forever. As your neighbor and Corvallis High School students here in Benton County who care about our home, please consider upholding this decision. Thank you.
Thank you. Steve?
Commissioners, my name is Steve Michaels. My address is 1215 Northwest Canoe Drive, Corvallis, Oregon. Here are a few of my thoughts in no particular order. It should be clear by now that the correct decision in this matter is a denial. With the evidence that you've heard over 2 days, you can direct your staff to prepare a legally defensible set of findings of fact that you could feel proud to affix your name to. The proposed conditions of approval create extensive data sets that are lacking objective cures to operational issues. Future odor, litter, fire, leachate, and methane problems can be solved now with a denial. Enforcement of the conditional conditions of approval will be a county burden. The extent of current complaints suggests that the $80,000 monitoring fund will be inadequate. Deference to state and federal agencies for landfill oversight is risky. Environmental regulations are not static. There is no guarantee that oversight agencies will be able to address permit issues or even exist in the future. Valley Landfills is a subsidiary of Republic Services. What happens if Valley Landfills is sold? Does the approval, if there is an approval, run with the property or the applicant? I haven't heard any information about that. That may already be in your code. I'm not aware. I also think the impact area is broader than what's been described in the application. Trash is trucked to the site from throughout Western Oregon. We haven't heard about transportation, air pollution, and litter problems occurring on
Thank you. That is your time.
roads.
Yeah, it goes quick. Thank you so much. Keith.
Keith Lemke. I live at 39046 Trillium Lane, Corvallis, Oregon. Been there since 2003. I am the chairman of the Benton County Republicans and speak for their consensus, which is probably the most important reason I stuck by, to let you know that. I have a doctorate in public administration, over 40 years of experience in public service. I'm going to discuss why we are against the expansion. I've tried to cut this down to something that has not already been covered. So it comes from a new way. First of all, it's hard to believe, but there's never been a public referendum on the regional landfill. There was early on the dump, but not on the regional landfill since 1974. And that was, I'm not going to go into the history. It's in my paper if you want to see it. But the bottom line is that the consensus of the county was to let 5 or 4 other counties put their trash into the dump until they helped devise a new system. The second part of that fell away, but the first part remained. And so from 74, I'm tired. Until now, essentially it's gone from 5 to 20 counties, not a single referendum. And it would be nice to have that. So how do we know what the effect on the general population is of the county? We really don't know. That's the political method to determine what their feelings of the effect of any policy is. And we just don't have that. So everything's been an assumption. And before, if there's no pushback, the assumption was that that was consents. But there's big pushback now. So it's not a valid assumption. I think it's probably important to note also that because there was no referendum, that's such a big thing. I mean, this thing's going to last 1,000 years by the time the last piece of plastic, is gone. And so you're talking about a dump that's going to affect, or a landfill that's going to dump, that's going to affect this county for the next possibly 1,000 to 2,000 years. And so why would we want to expand that any bigger? And certainly, why would we want to add any more danger to it over time? Which is one of the reasons to keep it the size it is. We already have a big problem. We just don't know it yet. There's an argument of all the people that were here yesterday. The biggest argument is it's too costly and too big to kill. Oh my God, if that goes away, what are we going to do, in particular all the other counties? Well, if it's really costly now, and if it's too big to kill now, in 30 years it's going to be bigger to kill, and it's going to be more costly. So if you're going to do anything now, if we don't, we're going to have this thing for a couple hundred years. Look at the land that has been bought by Republic. That's not a 60-year plan. That's a longer plan. And I mean, if I were them, here's what I'd be doing. I'd be getting myself ready for whatever the state does in 2040 and be ready to jump on it. Regardless, it's going to be in our backyard. I heard a lot of lawyers and politicians from the other counties advocate for the rights and interests of the franchise and the taxpayers. That's awesome. I would too. However, it's useless because it misses the point. This is about us. We need us. Well, our staff was sure to tell us what our concerns could be. They didn't really tell us what they could be. And that's the problem. If we need you guys' help, and we need your staff to be our advocate. If we don't have you or the staff at the county as our advocate, we have no one. And lastly, we know that they can't, the county can't enforce their statutory requirements for the safety of the landfill. So why are we expanding it? It doesn't make sense to me. If we can't do that, why would we recommend the expansion of something that we cannot independently enforce for the sake of our own citizens? It doesn't make sense to me. Perhaps it does to you. And lastly, I love experts, but they don't need to tell me what is important to me or how my life is affected by the dump. Thank you.
Thank you.
Commissioner.
Yes.
Chair, could we take a 1 to 2 minute break? I need
Just to like walk around the room.
I need.
Okay, yes.
Yeah.
Just very, very short break.
Yes.
Okay.
Well, you call up the
We're pushing through. So the next individual that I have signed up is Dan Chappell. Please come on up. And if we could have quiet in the room, Dan can begin his testimony.
Thank you for the very nice opportunity to address this board today. My name is Dan Chapel. I reside at 24241 Cardwell Hill Drive in Philomath. My wife and I are co-owners of Cardwell Hill Cellars, which is a environmentally sensitive company. We're certified sustainable agriculture. And I also serve on the Live Committee in Oregon, that's looking at the looking at the problems with the recycle of clear and colored wine bottles. I'd like to speak about the future with technology that actually could devour much of the material that's laying out there in that thing. In 1970, I was the engineer for a gasification project in Puerto Rico where we used Shell technology to gasify petroleum stock to generate 2-ethyl hexanol. Years later, in 1999 and 1998, I visited several plants in Europe that had extended that technology to processing industrial waste. One plant was a pilot plant in Italy, and the other was a plant in Karlsruhe, Germany. The Karlsruhe plant was devouring a mountain of municipal and industrial waste that was probably 30, 40, 50 meters high and several hundred yards long along the right parallel to the Rhine River, where seepage could occur from waste materials. One of the key issues in the design of these concepts is processing a variety of municipal waste. For example, gasification technology can process contaminated hospital waste, partially eaten McDonald's hamburgers, thousands of shrink wrap material, railway ties, and now becoming very important in this country, the huge debris generated by fires and floods. All of this material can be gasified and turned into electric power. In fact, it can be turned into electric power very rapidly. Excuse me, material arriving at the facility can be processed within a few minutes to generate electric power. For example, a trash bag, there is the T-bone left from a recent dinner. Once it's dumped into the receiving area, within a few minutes would be electric power produced by gasification and cleanup of the gas. There are several plants in Japan that have licensed this technology, and they've been used for a considerable period of time. However, there are some challenges. Change can be very threatening. Huge funding would be necessary. We would have to have good communications between local authorities federal government, state and local government. New roles would be with waste management companies who would have to dispose of material in the designated factory. And there would have to be coordination with electric power companies to take the electric power that's generated in a few minutes after the trash is dumped in the receiving bin. The present status is unacceptable. We are locked into transporting municipal and industrial waste to landfills and canyons. Will New York City be able to continue transporting waste all the way to North Carolina in the foreseeable future? We're looking at transporting waste across the state of Oregon. There is no credible path forward using the techniques that are underway today. We need to move into a technology environment of gasification to destroy this material within a very short period of time and generating much needed electric power, which is a growing demand in this country. For that reason, I hope this board votes against this primitive technology, this primitive procedure, let me say, that we have today, and work with others to go into a technical solution that is fully capable of this great country to implement. Thank you for your time.
Thank you, Dan. Do we have Ian Finn online? Okay.
Oh, hello. Hello, my name is Ian Finn. I am a resident at 28984 Blaze Drive in Corvallis. My property directly abuts the proposed expansion area. And pretty much it's going to bring everything about like within 800 feet of our house. Based on listening to all the previous testimony, which I especially agree with, I urge you to deny the conditional use permit for this expansion. Under the Benton County Code that's been talked about, 53.2151, a conditional use may not be approved if it would seriously interfere with the uses on adjacent properties. In my experience with the current facilities and what they're proposing, I believe that this conditional use shouldn't be approved because it will affect my use of my property. Specifically, odor, which has been talked about a lot. It happens all the time. There'll be nights where you come home and you're like, oh, I want to eat dinner outside, and you don't want to eat dinner outside because there's that landfill stench. There's a lot of issues with noise. I think somebody said earlier, either yesterday, something about like trucks lining up at 5 a.m. and I've heard them as early as 4, and on many days going a little bit later. And then the last thing that really has affected our property is the litter and like visual intrusion from both like lighting and what are the things that like blast off to get the birds away, and then as well as like the litter that comes onto the property, like the plastic bags.
Thank you, Ian. That concludes your time.
Thank you.
Okay, I'm going, oh, nope, Deborah Higbee is next. You're on
Hello,
live.
hello, Chair Wise and Commissioner Malone and Shepherd. My name is Deborah Higbee and excuse me. It's getting kind of late. So my name is Deborah Higbee and I speak on behalf of the 58,000 members and supporters of the Oregon chapter of the Sierra Club at 1821 Southeast Ankeny Street in Portland, Oregon. We urge you to reject the application for expansion of the Coffin Butte landfill. Expanding landfills should not be a waste management strategy. Expanding Coffin Butte would indicate that Benton County is not meeting the seriousness of the global crisis of climate change. Landfills are a significant source of CO2 and methane emissions, which contribute to global warming. In a June 23, 2022 EPA Clean Air inspection of Coffin Butte, they found numerous exceedances of methane and other gases. And in 2024 EPA inspection found dozens of methane leaks. Given that methane is so potent and shorter lived than CO2, reducing landfill methane presents an opportunity for climate mitigation. To extend the life of Benton County's landfill, a zero waste plan that includes a circular economy is needed. Others have testified that we should do this after the landfill is expanded, but it's needed now. The consequence of business as usual is climate change, resource depletion, pollution, and ecosystem damage. Waste should be treated as a resource. It's commendable that Benton County has been studying the issue of waste reduction through their sustainable materials management subcommittees. The task force gave its findings and their #1 recommendation is to decrease disposal. And #2 is to identify the most sustainable options for the remaining waste. So in order to fulfill the task force recommendation, you must deny the expansion of the Coffin Butte landfill. More than half of the waste sent to the landfill is organic. Therefore, to extend the life of the Coffin Butte landfill, a community and business composting program is essential. Why is this not a condition of approval, especially given that organics is the cause of methane odor and bad air quality? Republic Services voluntary composting program is not at the scale needed for waste reduction and climate mitigation. An important part of the decision-making process regarding Public Services application for expansion must include the communities surrounding the landfill, as you've heard this evening, who are subject to most of the harms. Solid waste management has long been a public health concern. It's a source of groundwater and surface water contaminants as well as pollutants. The Coffin Butte expansion will seriously interfere with uses on adjacent property, as you've heard, and with the character of the area. Yesterday, you heard testimonies from the decision makers from other counties, like Yamhill County, where residents strongly opposed the expansion of their River Bend landfill. Their efforts ultimately blocked the landfill's expansion. The Yamhill commissioners voted against the expansion due to worries about pollution, the potential for an earthquake, and a US EPA notice, which found the landfill was committing numerous violations under the Clean Air Act. That's similar to Coffin Butte. As I expressed before, the Coffin Butte landfill also received an EPA Clean Air inspection in 2022 and 2024. And they found dozens of methane leaks at the landfill. For those using the landfill's adjacent property who live, bike, or recreate in the area will be affected by poor air quality. Multiple peer-reviewed studies found that air provides a PFAS forever chemical pathway, which raises concerns for those who hike or recreate in the vicinity or live around Coffin Butte landfill, and those impacts will increase as it expands. So thank you so much for taking my comments into consideration, and we urge you to deny the application for expansion of the Coffin Butte landfill. Thank you very much.
Thank you.
Thank you.
I will go ahead and call 3 more people. David Kaloum, Julie Smirsick, and Lori Tully.
Good evening. members of this body. My name is David Coulombe. I live at 37741 Govier Place with my wife Elizabeth and her parents, Dennis and Karen Bailey. And I'm speaking on behalf of our family tonight. I'm also a retired attorney. I'm still a lawyer, although you can ask me later about the distinction between the two. I'm reminded at this proceedings of the endurance it takes. Was not looking forward to that reminder. Bodies don't sit in these chairs. Older bodies don't sit in these chairs for hours on end. I'm going to move away from the evidence, the technical evidence, and talk to you a little bit about process. Reminding you that you're in a discretionary review and you have great and wide latitude. Contrary to I believe it was the mayor of this, or an official from the city of Newport who mentioned that the criteria that you're reviewing is clear and objective criteria. And I know you know that's not true. The criteria that you're considering is subjective, very subjective in nature, and that's intentional. I would call it the squishiness of the criteria, and that's a legal term, I jest. The county's code, getting used to these reading glasses as well, another one of those aging issues. County code does not impose varying subjective terms for different conditional use applications. A vanilla residential cup is reviewed under the same text as a cup seeking to increase its footprint with millions of tons of organic and inorganic waste, some of which is toxic to humans and animals, as you've heard multiple times tonight. The level of risk resulting in serious interference and undue burdens and adverse impacts to adjacent property, character of the area, and level of undue burden on public improvements, facilities, utilities, or services available to the area requires a more stringent level of scrutiny. So the squishiness, the elasticity allows you to apply this criteria based on the seriousness of the interference, the risk thereof. Stated differently, the greater the adverse impacts, the greater the level of scrutiny, and the greater the applicant's burden. Speaking of the applicant's burden, it is one that's twofold. It is one of production. It is their obligation to produce to you the evidence to demonstrate compliance with every single applicable criteria. It is not the burden of staff. It is not the burden of the Planning Commission. It's not the burden of the public or opponents. Don't be misled. The sole burden lies with the applicant. The applicant doesn't give you sufficient information, which, by the way, is under their control, then you should find that their application is lacking and deny it. Given the testimony of the serious interference to Robert Kipper's property and use and other impacts discovered and submitted by the opponents in these proceedings amply demonstrate that the applicant has not met the burden, and you must deny the application. A point staff also noted in its oral report to the commission last night that the record is full of substantial evidence sufficient to allow you to deny this application. The criteria, BCC 53.215, the decision to approve a conditional use permit shall be based on findings. You can look at the first one. Proposed use does not seriously interfere with uses on adjacent property. The applicant has provided some definitions and some general case law and terms and how to understand your interpretation task. Plain language in context, parent purpose demonstrated by legislative history. Nothing wrong with that. It's a clear path. Start with the plain language of the text. With respect to discretionary, which is context, this is a discretionary review proceeding. The latitude, discretionary means latitude of decision within which a court or a judge, this is a quasi judicial proceeding, decides questions arising on a particular case, not expressly controlled by fixed rules of law, according to circumstances and according to the judgment of that body, in that case, court or a judge. So Webster's Third International Dictionary definition. So what does the text say? In context and intended purpose, disclosed by legislative history. Adjacent, a term you've heard. Black's Law Dictionary. Lying near or close to, sometimes contiguous, neighboring. Adjacent implies that the two objects are not widely separated, though they may not actually touch. While adjoining imports that they are so joined or united to each other that no third object intervenes. Black's Law Dictionary, page 62. You've also heard the term adjoining. Adjoining means touching or contiguous, as distinguished from lying near to or adjacent, to be in contact with, to abut upon. Black's Law Dictionary, also page 62. Adjacent from Webster's Third International Dictionary, in relevant part 1A, says not distant or far off, in parens, the city square and associated streets, close parens, nearby but not touching, in parens, for an example, the islands and the associated mainland coast. So you have city streets, city square, then you have mainland and islands extending out from the mainland. That's part of that elasticity in the area of impact. The applicant wants you to consider a very narrow area of impact. That limits their scope, that limits the scope of your review. In its presentation, the applicant's representatives, whether it's misspoke or not, substituted the term adjoining for the term adjacent. They are not similar. They are not synonymous, as the definitions that I just read to you explore and point out. The applicant desires to shield the proper review of its interference by limiting the area of review. The examples Webster's dictionary gives doesn't allow that process or that interpretation. I also found it ironic that the applicant's attorney went to such effort to explain to you the meaning of relevant, then his client immediately resorted to lobbying efforts totally unrelated to any applicable criteria. Regarding your relevant testimony, I found it amusing that public officials outside of the county, territorial limits, would testify that you should approve the expansion, no doubt to the delight of their constituents' pocketbooks and their own avoidance of housing such a toxic waste site within their own local territory. Chair Wise questions the staff and the applicant concerning the narrow scope of the consideration for interference to property use, character of the area, and undue burden highlights the lack of evidence a small compact consideration area leads to. Consistent with the chair's question and inquiry, LUBA has held that where code provision provides that where a proposal will have significant impacts on the area, the proponent of the proposal may be required to submit more detailed and reliable evidence that the proposal will comply with the applicable approval criteria than would otherwise be required in order for the county to approve an application with fewer impacts consistent with Fasano v. Washington Supreme Court case. It was set out and cited in a LUBA case, Tidewater Construction v. Curry County. Shows that elasticity, the provision that the greater the risk, the more serious the intervention, the larger the area should be and the stricter the scrutiny. I want to point out, I know my time is running short. I did want to point out, well, two things, but I'm not going to have time. So I will start with the conditions of approval and just note that a condition of approval as set out and defined in VCC 53.220 is not a substitute for meeting a criterion. The mitigation of serious interference is not the standard of proof required by the code. Demonstration that the proposed expansion does not seriously interfere with adjacent property
you,
is
David.
the standard. Thank you.
Thank you. Julie, please correct my butchering of your last name.
It's a weird one. Julie Smirchik. Yeah, thank you. I'm a licensed clinical social worker here in the state of Oregon. 2120 Northwest Elder Street here in Corvallis. As a 20-year veteran in the health and mental health fields, I'm acutely aware of the link between environmental conditions and human health. When we allow our environment to become sick, we become sick physically, mentally, emotionally, spiritually. Our capacity to participate as creative, vibrant members in the community becomes greatly diminished. I'm asking you to deny this expansion to protect our health. The leachate contamination that we've heard so much about of the Willamette should give us all serious pause. Communities downstream are forever going to be affected. Maybe DEQ or some other agency will step in to help us out with that. But right now, you are the only decision makers positioned to take some effective action. So please use this opportunity. I do understand that the leachate technically is beyond the scope of the CUP language, but it's not beyond the scope of our shared responsibility. Water is life, and expansion is only going to produce more leachate, more harm. So I feel at this point, you've been given all the evidence, testimony, and information you need to write a bulletproof denial of the CUP. I hope you feel that way too. I'm so proud of all the community members that have spoken this evening and last evening about numerous specific issues that hopefully will be helpful to you. And notably, the joint letter of opposition from Senator Gelser and Representative McDonald, they make it really clear that when you come together to say no and deny the expansion, you will be supported. They will have your backs, and we will have your backs. And we want to be able to support you. I'm urging you to hold the line, deny the expansion. I know it's difficult. I'm so proud of the people here. Make us proud.
Thank you.
Thanks.
Lori?
Hi there. Thank you for staying so late. I'm Lori Tully. I live at 4202 Scenic Drive in Albany. And my background, I am an electrical engineer, bachelor's, master's degree, worked as an engineer and manager for over 30 years. I've lived in Benton County since 1994, enjoying the many hiking trails, bicycling routes through here, and paddling in the rivers nearby. Love this area. It is clear that the decision to site a landfill in the geology of Coffin Butte many years ago was flawed. Unfortunately, the scientific understanding of risks wasn't well understood then, but we are no longer ignorant. Today, we know better, and we have time, 12, 14, 15 years, to come up with a better solution. Contrary to last night's testimony, there are better options for solid waste disposal, some that could take advantage of existing rail infrastructure, which is cleaner and cheaper than trucking. When I examined the staff report to recommend the expansion proposal, I questioned their conclusions. How can the staff dismiss some of the biggest issues with the existing landfill operation? Their report recommends not evaluating whether the application complies with state and federal air and water quality standards. Instead, the issue is punted to regulatory agencies to monitor risky operations and enforce actions to correct bad behavior. Ignoring the standards and assuming that monitoring and enforcement will lead to compliance is a faulty assumption, as we have seen. While the county doesn't have in-house expertise, it still has an obligation to ensure federal and state environmental and safety laws are met. If land use laws allow health and safety issues to be brushed aside, then it is time to change the laws. The staff report goes on to state that speculative matters regarding lack of compliance shouldn't inform the board's decision. Are you kidding me? The data presented on egregious leaks, dangerous fire hazards, and frequent odor issues isn't speculative. Lack of compliance should indeed inform your decision and is, in my opinion, a defensible position. Please ignore other advice. This leads me to another question. What about the existing EPA investigations in DEQ violations of air quality? These cases point to a history of failure under the existing use permits that rely on self-reporting and oversight to properly manage the risks of the existing landfill. Republic Services has no financial incentives to monitor the landfill for air and water quality issues. With the majority of the operating site self-exempted from their monitoring, Republic has shown it would rather turn a blind eye than responsibly manage it. Since past performance is a pretty good indicator of future performance, how many more violations would you expect under an expanded operation? Approving an expansion makes these risks more likely and more severe. Remember, the dose makes the poison. The staff seems overly concerned by hired consultants, influenced by hired consultants whose models suggest odor and traffic aren't severely impacting residents. This is a direct contradiction of public testimony with numerous citations of intolerable odor issues and heavy truck traffic creating safety concerns. Obviously, the models aren't adequately predicting the impact. If improving this expansion requires residents to stop recreating in their own backyards and turns county roads into death traps for cyclists and pedestrians, aren't these severe restrictions? Since the Benton County Code specifically addresses livability and character of the area, it appears that the staff is undervaluing these impacts. Of all these concerns lead me to question the validity of the staff report to approve this application. The recommendations appear to be too rigidly tied to interpretations that Republic Services has put forth. It should also be noted that the staff are not an impartial body to these proceedings, as they are county employees. And after hearing tonight's testimony, I'm very concerned about their neutrality. Obviously, Republic Services has a large financial stake in these deliberations, so their bias must also be taken into account. The citizens of Benton County are ultimately the ones who have to live with the consequences of this important decision. It is clear that the decision to site a landfill in the geology of Coffin Butte made many years ago was flawed. It is easy for other municipalities to extol the virtues of having access to a landfill that isn't in their backyard. They don't have to worry about the leachate while paddling or wading in the Willamette River. They don't have to worry about poor air quality, groundwater contamination, wretched odor, and heavy truck traffic. Republic Services hasn't demonstrated to be a trustworthy business partner and doesn't deserve to be granted an expansion. For the health and safety of the citizens of Benton County, please vote no on this application to expand.
Thank you. Commissioners, we have 5 people left on the list in 14 minutes. I think we should continue. I just want to note, I do not have the stomach to listen to one more person say anything negative about our staff. So if you do so, I will cut off your testimony. But please feel free to come up. All these people over here are doing their jobs. They didn't ask for this expansion. None of us asked for the expansion. Or Public Services asked for the expansion. We are all just doing what we legally have to do. And I really appreciate everyone coming in here and helping us make that decision. But please be gentle and kind with our staff. So next on the list, I have Elizabeth Kaloum, Jenny Sarlos, and Dr. Shelley Sue. Is Elizabeth here? Oh, okay. Apologies for the mix-up. Jenny Sarlos. Sarloos. She did, okay. We didn't mark that. Okay. Dr. Shelley Sue.
Good evening, very late evening. Can you hear me? Okay. My name is Shelley Sue. My address is 6065 Southwest Grand Oaks Drive, Corvallis. I have been a resident of Benton County for 52 years. Came here as a freshman in college. Never left. I loved it. I am a PhD toxicologist. I'm a former OSU faculty member, and I also was an EPA employee who specialized in the fate and transport of air toxics. Okay, so I feel like I have. Now, most of the people have already talked about everything I was going to talk about tonight because I'm number 168. Okay, and I really was going to give a technical talk about how I felt about some of the chemicals that have been underreported, understated, their danger. And I think that's been overdone. But yesterday when I came to the hearing, I changed my talk because of what I saw yesterday. What I saw yesterday was people come in to get they want to have their business expanded, and yet they want to dictate all of the parameters for how we're going to talk about everything. We had a very long discussion about some crazy term D over T to describe odors. Frankly, I'm tired of hearing about odors. These are toxic carcinogenic chemicals, okay? They're carcinogens. Nowhere in their report did I hear them referred to as carcinogens. People who are living in and around this area, these are carcinogens. And nowhere did I hear about the fact that these chemicals get transported to disparate sites, okay? We were told that we had to, that we were only allowed to consider their effects for a quarter of a mile around the facility. 1,320 feet, okay? Now that seems ridiculous to me when these airborne carcinogens are traveling miles to affect people, wildlife, water, everything else for miles around, okay? I don't want to hear them called odors. They're not odors. They're dangerous chemicals, okay? We were told that they dictated all of the parameters for how we are to listen, how we are to decide, as if they are in command and control, okay? I think the thing that we spent 30 minutes talking about the word adjacent and how we should define it. That's ridiculous, okay? But it seemed very, very important to them. I think the most disturbing thing that I heard is how we weren't allowed to discuss or consider any of the aspects of their past performance. Now, someone just recently mentioned this. That is absolutely ludicrous. Most of the people in this room that are over 40 have probably hired someone in their life, interviewed someone for a job. When have you ever hired someone but said, I'm sorry, I don't need a resume. I cannot look at any of your past performance in any job that you've ever done in order to decide whether I want to hire you or not. That's ridiculous, okay? Past performance, as this woman before me said, is the primary indicator of future performance. My mother was a judge. That was the primary.
Do we lose audio?
Yeah, I don't blame you. I cut me off too.
No, one moment. Can we pause
Okay.
the timer, please?
My
Oh,
mother
never
was a
mind.
judge, and her primary consideration for how she was going to sentence someone was what their prior behavior had been in life, okay? Everybody considers prior behavior when they consider future recommendations of what they're going to do with someone in the future. So I do not understand why Benton County feels the need to operate or accept all of these ridiculous rules in determining whether or not we're going to expand this landfill. Past performance is the #1 indicator. And as people have shared tonight, there are many, many, many things that we could point to show that past performance has been underwhelming. I was not impressed. In fact, I was a little bit offended about all of the talk about monitoring. As a scientist, we know monitoring is not measuring. Monitoring is not taking action, okay? Monitoring doesn't do anything, okay? If you're gonna monitor, you have to do something with that after you monitor it. But it sounded to me like all they were gonna do is monitor it, and they're monitoring themselves. So we don't even get to decide whether they're gonna report their monitoring correctly. I don't trust them. Now, I was gonna talk about a lot of other things, but I'm just gonna say the following. You have an opportunity to determine our future and not to turn Benton County into a Superfund site that will last for 1,000 years. I urge you to vote no, and our future depends on it, but don't let it keep you up at night. Okay, thank you very much.
Thank you. Is Marcy Follett in the room? Come on down. You're the next contestant. It's getting late, folks. It's getting late. Good.
My name's Marcy Follett. I live at 14605. Can you hear me okay?
Maybe a little closer.
Okay, here we go.
There we go.
Like a, what is that? Ice cream? Okay.
Yeah.
Okay, 14605 Corvallis Road, Monmouth, Oregon. I live in Benton County. Depends on which bathroom I use. Okay, get back to it. So the question that has not been asked or answered is why? Why are we not supposed to put a landfill on that side of the road? And there could be quite a few very good reasons why we shouldn't do that. If you look at the geotechnical section of my report that I turned in, you'll see that in itself should have you denied the application. But the one possibility is that the people in 1970 had information that we didn't know. And that is that that was part of Camp Adair. Therefore, we have potential for underground infrastructure. There is infrastructure underground. Does it go close enough to cause a problem? Is there underground ammunition? Is there dumps? Is there chemical dump there? This site is next to a dump. Therefore, it's very feasible that there is stuff buried there that the trees are okay over the top of, but we don't want to tap into. And since that question has not been asked or answered, we cannot assume that it is safe to put that there. So that in itself should stop us. And I've been really sad to hear everybody say how we need a plan, we need a plan. In 1974, there was a plan, and it wasn't that we have Coffin Butte. The plan was that Coffin Butte was there to hold our waste, which would give us time and technology to advance so that we could eliminate our need for the landfills. That the documentation from that time has been lost or set aside or whatever happened to it. and the plan was forgotten. So back in that time, Tom McCall, as our leader, we showed America what it would take to clean things up and that we could do it and be prosperous, that we could have jobs at the same time. And it's time for Oregon to once again step up and say, it's time for us to show America that we can have a clean environment and we don't have to be controlled in order to handle our waste, because that is the new plan and it's unacceptable.
Thank you. All right, everyone. Oh, let's see, I was told Lindsay Adrian is not online, but we will check one more time. Still not online. Is Lindsay Adrian in the room? Adrian, Lindsay? Hearing none. Well, that concludes our testimony for the night.
I think it's okay to clap. I think that's okay.
Yes, we do. I mean, you can go if you want. We aren't done yet. Let's see. Okay, I've got so many notes. So we do technically owe Republic Services a 30 minutes rebuttal period. However, they have offered, since it is so late and we have figured out a way to keep the record open for a little bit, that we will let them submit that. But I believe you are available to hear the specific questions that we have now that you can incorporate into your rebuttal. What? Okay, we're gonna take just a couple minute break to collect our thoughts and stretch while you guys sit down. Thank you. All right. I'm sorry, we're a little punchy. It's late. Thank you for your patience. It did get later than we were hoping tonight. So questions for Republic Services, and my understanding is that we're asking you the questions that we're most interested in, and then you will include the answers in your rebuttal that you provide in writing. Is that correct?
Correct, Madam Chair.
Okay, and then obviously you can include everything that you see fit in that rebuttal as well.
Thank you.
Who would like to go first?
There's been quite a bit of mention of the lifespan of Coffin Butte and number of years, and at some point it would be helpful, and a range is perfectly acceptable. Hard to predict the future at times, but that would be helpful in thinking about the future, not so much the CUP part of the business, but also being able to look ahead.
Yeah, we can definitely provide that for you. No problem.
And I guess that also ties into the tonnage cap that we talked about yesterday, and I think those two items are related.
Okay, no problem.
I have 4 questions. Number 1, is your current, is your current fencing, goodness gracious, what did I write? It's essentially, is the fencing at the current existing site the same that's proposed to be for the expansion?
Okay.
Number 2, approximately how many non-Republic owned vehicles visit Coffin Butte daily / annually? And do you know how many of those are commercial? And I think, I assume some of this is in the record already somewhere. Number 3, if someone calls in with an odor complaint, how is that currently logged? And is that different from what is proposed, how it's proposed to be logged? And part two of that, how does the applicant, how do you log complaints that you deem, that you substantiate versus claims that you don't substantiate? And number four, what is the plan for the disposal of leachate generated by the expansion proposal? Those are my four questions.
I'm so sorry, Commissioner Shepherd, could you please repeat? Well, I think it was either the third or the fourth one, when someone calls in to report an odor?
Yeah, essentially, when someone calls in to report an odor and if Republic deems that that is an odor from the landfill, how is that recorded? And if Republic deems that is not an odor from the landfill, how is it recorded?
Is it recorded or determined? Recorded?
Determines, well, no, I want to know if there's a record that you keep of these calls, that even if you determine that it's not from the landfill.
If we go to investigate and we're saying that it's not necessarily an odor caused by the landfill, are those still captured?
That's what, yes, that's my
Okay.
question. Thank you.
Okay.
All right, I don't have any specific questions for you. I'll just tell you what's most helpful for me as you are, providing the burden of proof. I guess some sort of like bullet points or sort of straight to the point, the themes or the arguments that you heard today. If you have a rebuttal to each one specifically, if you could at least list those out in just a clear, succinct way, that would be most helpful for me.
Understood. So maybe responses maybe put together by category or themes as opposed to kind of scattered all over.
Sure, as opposed to some like, we're gonna just have a long conversation with lots of paragraphs.
Gotcha.
Yeah.
Okay.
I also endorse bullet points.
Okay. They're easier to write as well, so I think that'll work out okay.
Perfect. Any other questions or feedback? No. Are you thinking, or is that a no, Commissioner Shepherd?
Oh, I'm done. No.
Okay. Are we good at this point to? Okay, so I have a script somewhere here. Okay. Open record period script. The board has received a request from a member of the public to leave the record open. Since this request is not from the applicant, there is no extension of the 150-day limit, which is approaching shortly. Pursuant to ORS 197.7974B, for a local appeal hearing, if additional documents or evidence are provided by any party, the local government may leave the record open to allow the parties a reasonable opportunity to respond. The board has determined to leave the record open until Wednesday, October 29th at 4 p.m. to allow persons the opportunity to respond to additional documents and evidence submitted at these hearings before the board. Documents or evidence submitted into the record between now and Wednesday, October 29th, 2025 at 4 p.m. shall be limited to responding to documents or evidence submitted into the record at these hearings. Any submissions must be in hard copy form and received in the Board of Commissioners office at, this says 4550 Southwest Research Way, 4500. Our address is 4500 Southwest Research Way, Corvallis, Oregon, 97333 by 4 p.m. on Wednesday, October 29th, 2025. Any submissions received after that date and time will not be included in the record and are rejected from the record. So don't get there at 4:01 p.m. This hearing is continued to November 4th, 2025 at 1 p.m., at which time the Board of Commissioners will convene and deliberate to a decision on the appeal of the Planning Commission's decision in LU-24-027. Do commissioners have any questions on that?
No questions.
No. Okay. What else do we need to do?
Continue the hearing to November 4th.
And with that, we will continue the hearing to November 4th at 1 p.m. at 4500 Southwest Research Way.
Yes.
Board of Commissioners office, not here. Thank you so much, everyone. Have a good night.